Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-1352. Maryland Office of People's Counsel et al. Petitioners versus Federal Energy Regulatory Commission. Mr. Schwartz for the petitioners, Mr. Perkins for the respondent, Mr. Hughes for the interveners.
Mr. Schwartz, good morning.
Good morning, and may it please the court. Jeffrey Schwartz for the customers. The Federal Power Act requires that all wholesale electricity rates be just and reasonable, and makes no exception for auction set rates. And under Section 206, if FERC finds an existing rate to be unjust and unreasonable, it must set a new just and reasonable rate to be observed thereafter. FERC here concedes that it may exercise this authority over auction set rates in other cases, and it concedes that a mistaken parameter in this auction caused exorbitant prices that its brief calls wasteful and its commissioners called patently inequitable and blatantly unjust and unreasonable. Those rates charge Delmarva customers an extra $180 million for no economic or reliability purpose. Although it recognized the injustice, FERC denied the customer complaint because it wrongly believed a Third Circuit decision foreclosed relief. Here's why that's wrong. Power providers rejected a change to the auction's rate-setting process. To implement the decision, FERC reversed the change, and PJM reran the auction with the original parameter. That fulfilled the court's mandate, ended the dispute about how the auction should run, and created new forward sales commitments at the higher prices. The complaint here posed a new question, which the Third Circuit did not decide, whether the resulting capacity prices were just and reasonable, as required by Section 206 and this court's precedent in Public Citizen and New England Power Generators on review of FERC's decision in Devon Power. The parallels between this case and Public Citizen are striking. In both cases, an auction was held under FERC-approved rules. The auction produced anomalous prices, which complainants challenged before capacity delivery began. FERC acknowledged the misfire and changed the tariff going forward, but it refused to evaluate whether the completed auction's results were just and reasonable.
So you agree that your proposed fix would have the exact same economic effect as the fix that the Third Circuit declined to impose, right? Or in fact, held was contrary to the filed rate doctrine?
Well, the Third Circuit was not ruling on an economic outcome. It was ruling on a change to the auction's rate-setting process, and found that it was too late to change the auction rate-setting process, and found that the potential inequities of setting such a rate could not save an impermissibly retroactive change. What we are challenging in this case is...
I think what FERC is going to say, or what they did say, is if we now grant your 206 challenge to the price and institute the price using the wrong auction rules, we would essentially be defying the Third Circuit. So why is it unreasonable for FERC not to want to be seen to be defying the Third Circuit's bottom line conclusion?
So two points, Your Honor. First, if the rates produced by the existing auction under the old rules are unjust and unreasonable, then it becomes FERC's obligation to set a just and reasonable replacement rate. We requested a replacement rate that tracked the results of the February 2023 auction because those auction results are market-based. They reflect the accurate reliabilities and supply and demand conditions in the market. So we thought that was a just and reasonable replacement rate. If FERC believes that for some reason that replacement rate is unavailable, then it's FERC's obligation to develop a different just and reasonable replacement rate. And I would add that the Third Circuit disclaimed consideration of the equities. It never held that the February 2023 prices were unjust and unreasonable, or that the May 2024 prices would be just and reasonable. That was sideways to the question before the court in that case, whether that change was retroactive. Contrary to FERC's
So
view.
I think the other flavor of this, to give you a chance to respond, is that FERC saw itself as bound by the Third Circuit's conception of retroactivity. So if you attach a new legal consequence to past actions, that is essentially what the Third Circuit said was impermissible. And they would say, you are in effect nullifying the outcome of the auction. So why can you do that consistent with retroactivity?
I would disagree, Your Honor. So in the power provider's case, what was sought was a rule change that would have produced the prices that came out of the February 2023 auction, the low prices that we think are just and reasonable. It would have been then the generator's obligation to challenge those rates and prove that they are unjust and unreasonable. Instead, on remand, FERC reversed the change to the rate setting process, reran the auction with the original parameter, and produced the higher rates that we now contend are unjust and unreasonable. So the outcome of the rate setting process flipped the burden to challenge the resulting rates, and we accept that burden. In effect, what the Third Circuit held was that the attempt to change the rate setting process in the middle of the auction was invalid and ineffective. The result was that the auction was completed in compliance with the rules that were in place when the auction started, just as was the case in Public Citizen. And just as was the case in Public Citizen, FERC acknowledged that there was a problem with those rules, which it changed going forward. And FERC has an obligation to consider whether the results of the completed auction were just and reasonable.
I have kind of a practical question. When PJM filed its Section 206 complaint back in December of 2022, it requested a refund date effective December 23rd, 2022. And how could that have worked in practical terms if the commission had granted the 206 complaint rather than PJM Section 205 filing? How could refunds have been paid for a rate that wouldn't come due until 2024?
I don't think that in the earlier Section 206 case, the refund effective date literally would mean refunds. I think it's something that
It would sort of be an offset.
is requested
a
as
conceptual refund ex ante.
yeah. I mean, had FERC acted pursuant to Section 206 before the auction was completed, the auction would not have produced any unjust and reasonable rates to refund. I mean, I think because
So the 206 complaint was sort of a nullity at that point, or didn't come into play. It's a preservation.
well, PJM filed under both 205 and 206, I think, out of an abundance of caution and to give FERC additional flexibility. If it didn't like the specific change that PJM was proffering under 205, having filed under 206 would let FERC craft a different solution if it believed that was just and reasonable.
The interveners seem to essentially argue that FERC is always powerless to set aside, even on a prospective basis, auction set prices for an upcoming year. And you argue that that would mean FERC is essentially powerless to set aside any price because every price is generated for some future period. And there's a rule involved that dates, that's the price that will be charged for the coming year. And can you just sort of explain, to the extent you're familiar, how this works outside the auction process and whether that would be distinct in any way that would bear on this argument? So how do formula rates work?
Well, I was going to go to a different example, Your Honor.
Yes, please.
Instead of conducting an auction to determine with whom PJM would contract and at what price and for how much capacity, in theory, PJM could negotiate individual contracts with individual sellers for capacity. Those would be familiar market-based rate contracts entered into under the seller's market-based rate authority. And there's no question that FERC has authority to review the justness and reasonableness of those transactions under Section 206. The standard may differ based on whether Mobile Sierra applies, but there's no question that FERC has Section 206 power over those rates.
So the interveners argue that, power providers aside, the filed rate doctrine itself protects this auction set rate and the particular parameters chosen back in February of 2022 from change before the delivery year. And they point to, in the briefing, some provisions of the tariff that they say compel that conclusion. And I know your argument is that FERC didn't deny the complaint on this basis, so we can't affirm on that basis. But can you address that argument just on its merits? How do you read those provisions?
I would say two things, Your Honor. First, harkening back to the analogy I used with Judge Garcia, if instead these were market-based rate contracts individually negotiated, those contracts, and let's say they were reduced to writing, those contracts would say, here's the price, and PJM must pay this price during the delivery year. Every executory contract it requires payment of the filed rate, even if there's a tariff rate that doesn't explicitly require it. That's the import of the filed rate doctrine, is that the rate must be paid until it is changed prospectively by FERC under 206.
And the fact that the litigation was filed and the 206 complaint was filed makes it prospective, even though now it would be in the past.
Correct. The complaint was filed before any capacity was delivered or any payments were made.
You rely some on Citadel. Does it make a difference that we're dealing with forward capacity auction here and there? We dealt with a change to a tariff that was governing the real-time energy market.
Well, we rely on Citadel primarily for the notion that imposing a dramatic price increase for no reason, for no benefit, and in this case, for no economic or reliability purpose, is itself unjust and reasonable. That helps to define what is unjust and unreasonable. I recognize, Your Honor, that in this case, we're talking about forward capacity auctions. And in that case, we're talking about energy transactions. But in both cases, the changes that were sought would operate prospectively as to future energy sales or future deliveries and payments for capacity.
And then the notion of a refund before the price has been paid during the delivery year is just, as you say, it's an offsetting if it hasn't been paid and it's eventually.
And in this case, we filed the complaint in this case, because of the Third Circuit litigation, the timing was compressed. So PJM reran its auction just days before the new delivery year. We filed our complaint while the case was pending on remand. And as a result, PJM went ahead and reran the auction and produced the higher prices that are being were being collected during the delivery year. They should be subject to refund. The entire delivery year is within the Section 206 15-month refund period.
And in terms of what the filed rate is, I mean, the filed rate is the formula, but the filed rate is also the parameters chosen at the requisite dates to plug into the formula? Is the filed rate also the price that the auction produces? Like when we talk about the filed rate, it's, in the old days, the rate was the price paid to,
Right.
to the.
It becomes confusing, Your Honor. I think the confusion is this. There's a buyer and there's a seller. And in the ordinary case, and the ones we're all familiar with from decades of the Federal Power Act, the seller files a rate, and that's it. There's one rate, right? Here, what you have is market-based sales of capacity by the sellers to PJM. But PJM's side of it is being dictated by the terms of its tariff. So the tariff is determining in the first instance how much capacity PJM is going to buy from whom and what price. And it's resulting in new subsequent filed rates for the sale of capacity pursuant to the market-based rate sellers, market-based rate authorizations. So they are both rates.
The formula is the rate, the chosen parameters going into the formula, part of the rate?
So the part of the rate that dictates the rate setting procedures and requires the posting of the reliability requirement would be part of PJM's filed rate. The specific reliability requirement itself, the number, isn't specified in the tariff. That's something that PJM develops.
But a process for selecting it is specified in the tariff, and it had to be in February 2022. It had to be specified and made public by then, right?
Correct.
So the number is not part of the rate?
No, I think you
The
could.
variable within the formula.
I think you could consider it part of PJM's filed rate. Again, that's distinct from the auction results, which are themselves market-based rates subject to FERC's authority.
Right.
And I would add, Your Honor, that you can find that inherent in Public Citizen, which rejected Public Citizen's claim that auction set capacity prices had to be filed with FERC under Section 205 before they could take effect. And the response was, no, that's not true because that's not how market-based rate sales work. Market-based rate sales, the initial authorization is the finding that sellers lack market power, right? Then transactions are entered into, but FERC has authority to review the justness and reasonableness of the market-based rate tariffs, even though they are not filed with FERC. If somebody files a complaint, FERC can review it. The only question is what standard. And that you can find that in the Supreme Court's Morgan Stanley decision. It's inherent in this court's New England Power Generators decision on review of Devon Power and in Public Citizen.
Except isn't this different from Public Citizen in the sense that it's the sellers who kind of undercut, the sellers' exercise of market power undercuts the initial authorization that they don't have market power. Here, it's FERC that undercuts the determination. Does that make a difference?
No, Your Honor. And first, I would say that in Public Citizen, there were multiple things going on. There were, in fact, allegations of market manipulation or exercises of market power. But what enabled that to have an impact on the prices were flawed market rules, including a flawed local sourcing requirement, which is the analog to the reliability requirement here. And in this case, the outcome is exactly the same. I mean, in this case, what happened was instead of a withholding of supply, there was an overestimating of demand. And the overestimate was not only more than was needed, but also more than was even available in the zone. As a result, there was an artificial shortage, which means that all sellers in that zone had market power. And prices rose to an arbitrary cap.
Okay, we'll give you a couple minutes in reply.
Thank you, Your Honor.
Thank you. Mr. Perkins?
May it please support Jason Perkins for the commission. The Third Circuit did not leave room for the commission to solve this problem again the second time. From the way the case was decided, presented to FERC in the beginning, from how it was decided by FERC, and then presented to the Third Circuit, the whole setup of the case was that there had been a problem already and could FERC fix it. The determination of the Third Circuit was it was too late. And in this follow-on proceeding, we were asked to take another look at the same rate to address the same situation. And the question was whether or not it was too late. And we decided, of course, to follow the mandate of the Third Circuit that was clear and unambiguous, straight out of the interpretation of the PJM tariff, which is the rate on file here. So to address some of the court's issues or questions topside, yes, we are dealing with the same economic effect here. Essentially, the parties have only identified two different points on the supply-demand chart. And
It is the same economic, their fix is the same economic effect, but the route to get there is very different. And the legal question in this case is whether this resulting price is unjust and unreasonable under Section 206. And I don't think the Third Circuit was presented with that question, were they?
Not precisely the same question. The question they were presented with was the calculated and posted LDA reliability requirements, they called it. What effect does that have in the process? And they determined that it must be used in the auction. And they derived that determination straight out of the language of the PJM tariff. And of course, we argued for a different result in that case. And our theory was that until the process ran its course into having capacity commitments that are secured, it's not retroactive. The commission can still make changes. Squarely and soundly rejected in that case. And so we can't square the result here, the suggested result here with that reason.
Rejected as the tariff amendment, but not addressed with respect to whether the tariff rate was unjust and unreasonable under 206.
Right. It was not reviewing a determination of whether or not it was unjust and unreasonable, but to Your Honor's earlier discussion about the original presentation of the case, the 205 filing and the 206 filing, essentially the 206, the original complaint filing from PJM was an invitation for FERC to decide whether or not anything wrong had happened in the early parts of the process. And there's a certain path dependency to how the commission decided it. It decided because the tariff fix was not retroactive, it could go ahead and take that route. And it didn't really develop the record any further as to whether or not there was something wrong that happened that would enable a substitution of a new rate entirely. And as we pointed out in our brief, there was some suggestion carried through the case from the original intervener petitioners that perhaps a full reset of the entire auction might have been a path not taken. And that sort of logic is also not consistent with how the Third Circuit decided the case.
But it seems to oddly obviate a very central responsibility of FERC under the statute, which is that FERC has to determine under 206 whether a rate is just and reasonable. And it didn't do that here. It sort of put the cart before the horse by saying, well, we don't need to do that because however it comes out, the relief is unavailable. So if FERC believes for completely different reasons from justness and reasonableness or unjustness and unreasonableness that a potential rate is unavailable, it can just skip the unjust and unreasonable inquiry. I see so many of our cases that saying that it's FERC's job, not the complainant's job, to confirm that a rate is just and reasonable.
Generally speaking, that's right. I think that the second part of the inquiry has been identified as being the commission's job to set the, as we would call it, the just and reasonable replacement rate. But when there's essentially no flexibility left as to setting a new just and reasonable replacement rate because the filed rate doctrine is attached, that's a different situation. And so we would,
But there, I mean, public citizen was a rate that was, under the filed rate doctrine, but unjustness and unreasonableness is an inquiry that the commission applies to filed rates.
Specifically in public citizen, it was an auction result. We agree with that, but there was no discussion of any particular provisions of the mid-continent tariff that would have necessarily put that result beyond FERC's reach. That was the question that was set up in power provider's case here.
So why wouldn't, if that's right, would FERC approve a tariff that included a term saying, and by the way, this tariff waives any right to assess the rates it produces for justness and reasonableness? Is that something that FERC has ever approved? And if it came before the commission, is there a reason why, any authority to approve such a tariff rate?
I'm not aware of a specific example of that. This tariff does include language about when the result becomes final. And so that's
right. But it's subject under myriad determinations, FERC and of this court, to review for whether it's just and reasonable.
Under certain circumstances, it could be, but the issue of the filed rate doctrine basically takes this into a different realm in the sense that if you look at this court's decision in Oklahoma Gas, for instance, where Southwest Power Pool was trying to figure out how to come up with a formula to charge or reimburse for certain charges for use of certain facilities, it was a complicated process. It took Southwest Power Pool something like 8 years to figure out the right way to do it. And they claimed that everyone was on notice. They were trying to fix the problem. And so when they wanted to back bill for all of that time, they said, everybody knew we were going to do this. But the tariff itself had a limitation of only 1 year looking back to bills. And we gave effect to that. This court affirmed it. That is the sort of situation we're dealing with here. It wasn't the result that we advocated for in power providers, but the way that the Third Circuit decided it, so that attached earlier in the process.
If the power providers case had never been brought and all we had was the auction runs, there's a price, and they argue it's unjust and unreasonable, has FERC taken a position on whether changing that price prospectively there's no dispute that this is literally prospective as to the price. Have you taken a position as to whether that would violate the filed rate doctrine?
Not specifically here. And so I think it is hard to say for certain.
Have you, has FERC in another case taken, I presume someone would have told us, this issue just hasn't come up?
Not in this particular type of context, not that I'm aware of.
And so why would it be any different than what Petitioner's Counsel says, which is this time the price was set by an auction, but you might set it by a formula or a market negotiation, and every time they're going to agree, thou shalt charge this price for the upcoming year. And we all know you can set aside that price, not if it's already started being charged, but for the remainder of the period if it's unjust and unreasonable. And it's hard to see the Third Circuit as being presented with that question. And frankly, I'm a little skeptical that there is some kind of vested right from an auction. So I'm sorry, I guess my question is, it does seem like the intervener's position would immunize not just auction rates, but every rate from being set aside as unjust and unreasonable.
It would be much harder to set aside a rate. That's right. And we would have to do an analysis of each individual tariff provision and how they actually interact with the rate and whether or not the rate has been settled. I mean, this is one of the reasons why the commission did not adopt the Third Circuit's perspective from the beginning, is that it does seem to bake in many more steps to the process than the actual end result, which is the clearing price and the capacity commitments.
But it seems like you're then giving up something that the Third Circuit didn't even claim. It didn't do a Section 206 analysis. It's really looking at whether the tariff could be amended to resolve the problem apart from any review for justice and reasonableness. And it just seems unprecedented to then say, well, because this different path to the same or similar outcome comes to the same or similar outcome, that too is disabled. I mean, even where Mobile Sierra applies to, and there's an auction set rate, the 206 inquiry is assumed to apply.
Right.
Mobile Sierra is just a presumption, and what rebuts it, but a showing of that the rate is unjust and unreasonable.
Right.
And as the plaintiff's counsel explained, or petitioner's counsel explained that there is a difference here where the burden is shifted. So it's not the inquiry that the Third Circuit ruled on. It's a different question.
Well, to explain, why the commission reached the result that it did, if you look at pages 401 to 402, really sort of the end of the Third Circuit opinion, it cites this court's cases on the filed rate doctrine. It explains predictability as important. The doctrine forbids post hoc tinkering. It cites the dissent from Commissioner Danley that did not think that a change was possible here. So all the signs that we were getting from the Third Circuit opinion was this rate result is already attached. It is beyond FERC's reach. It is like in Oklahoma Gas, the periods before where Southwest Power Pool had told people they were going to make a change, but they hadn't actually done it. So
it might be totally reasonable that FERC, humbly interpreted this decision that way. But I think you've agreed that the Third Circuit just simply was not presented. And FERC might be right that you still can't change the price. It was not presented with the question, does it violate the filed rate doctrine to set aside this price? And that seems like something FERC needs to address.
Well, respectfully, we did in the paragraph 10 of the rehearing order, there is a very important distinction that we're making here. And I hope it helps answer some of the court's questions from this discussion. It's on JA 293, it's rehearing order paragraph 10. And it says that PJM's tariff specifies the rules for calculating the rate, i.e. the auction clearing price. And the Third Circuit found that under those rules and applying the filed rate doctrine, PJM must use the originally posted LEA reliability requirement to produce the rate. And so we're talking about a change to the formula after it's already been run. And that is the problem, essentially. So
That's a change to the formula, which you can do a rebate analysis without any change to the formula. The formula's been honored, the auction's been run, prices have been produced.
Well, we have made distinctions between like the pure tariff rate, like the utility says, the price is X. And Counsel for the customers talked about the bilateral contract rate, where the rate is A will sell to B at the price of X. This process is the rate, essentially, because it's the entire process PJM used, the multi-step process, to figure out what a market outcome might look like if all of those buyers and sellers got together. But PJM is taking that on and taking the steps and doing all the work to figure out what the right clearing price is in each one of the zones that it has to consider separately. And so if we are to come back and readjust the process later, it is going to affect what the outcome would have been the whole time. And that's sort of why we see the Third Circuit as having controlled this, even though, again, we did not adopt that particular view of how the filed rate doctrine works. We will give it effect in this case because it has already gone to judgment, and it is obvious. We thought it was obvious with the Third Circuit.
Is there anything that says, so if you had a different case where an auction went awry by assumption and the price is too high, it's not obvious that you have to rerun the auction to set the just and reasonable replacement rate. Maybe you can look to the rate that was reached in another, neighboring geographic area and just sort of choose that rate. Does that sound right? The FERC would have sort of remedial discretion in how it arrived at the replacement.
Right. The underlying problem here being, as we said in the original order, it was no economic reliability justification for the actual result reached. If FERC developed a record to figure out what result would have an economic or reliability justification, then yes, the commission would be able to set a new price, determine what the quantity would be. We're talking about prices and quantities, and FERC could come up with a different solution to that, assuming that there is a developed record to make an informed choice. But in terms of when the commission can reach back retroactively to disturb results that might otherwise seem final. I mean, the public citizen case, we read that as being a case about market manipulation where there was an independent violation of law. And so there was a problem that subverted the filed rate. So it didn't get into discussions of the filed rate, but there was a violation of law alleged there that the commission didn't reasonably explain or respond to. And so that is somewhat of a different circumstance than what we have here. That's why it doesn't really answer the question about disturbing auction set rates in this context.
And just to clear, I appreciate the portion of paragraph 10. Paragraph 17 says the commission's authority to otherwise modify auction set rates, otherwise meaning absent this Third Circuit decision,
Yes.
is not at issue. In other words, we are not telling you whether we could set aside this auction-based rate if not for the Third Circuit decision. So
Right.
this case is just about, did the Third Circuit decision foreclose you from addressing that question, right?
Correct.
Okay, thank you.
Okay, thank you.
Thank you.
Good morning. May it please the court, Paul Hughes for the interveners. Petitioner's complaint is an effort to circumvent the Third Circuit's decision. In light of that holding, FERC did not act arbitrarily capriciously for two reasons. The first is that the Third Circuit's P3 decision required a specific result using the LDA reliability requirements. Because petitioner's complaint seeks to undo that result, FERC was not arbitrary and capricious in rejecting the challenge. Second, apart from the Third Circuit decision, the filed rate doctrine does bar the Section 206 complaint that petitioners have brought. I'd be happy to start anywhere that the court may wish. To start though with
Yes, the first question jumps to mind is that I think FERC just said they didn't take the second position. So even if you're right, one view would be that's not a basis for affirmance. Do you have a response to that?
Your Honor, at the rehearing decision at paragraphs 13 and 14, I know it's characterizing the Third Circuit, but what FERC said was the Third Circuit found that this result was required irrespective of the possibility of any harsh result in this case as an application of the filed rate doctrine, which flows from the text of the Federal Power Act. And then at paragraph 14, it goes on to distinguish case law because it wasn't addressing the filed rate doctrine. So I do think what FERC is recognizing is that the filed rate doctrine is doing the work here. But what I think FERC is recognizing correctly is that P3 has essentially resolved this question because in P3, for example, the court recognized that one of the arguments that the commission had made in first accepting PGM Section 205 filing in the action before it was, quote, the panel, and this was FERC, concluded that the tariff amendment was not retroactive because the auction had not yet obligated any suppliers to provide capacity or determine clearing prices. So the kind of argument that because this was prospective on later prices or delivery was before P3. That was an argument that FERC had rested on in finding and approving PGM's proposed 205 filing for the tariff amendment. And P3 had no problem rejecting FERC's entire position there.
I think petitioners would say that that's all well and good, but the actual issue in front of the Third Circuit was whether you could change the rules of the auction. And it is a legally and logically distinct question whether you can set aside the resulting price that comes out of that auction. And that latter question simply wasn't presented in the Third Circuit.
Well, Your Honor, I don't think the Third Circuit viewed those as two distinct issues. And that's because in its own opinion, it recognized this separate part of the case, which was what FERC had relied on before, was the prospective effect on rates. And that didn't have any bearing on what the court ultimately held. And I don't think there was any suggestion that if the 206, the PGM 206 filing had been present in the Third Circuit, which the Third Circuit acknowledged the existence of, that there somehow would have been a different result. And I do think
it just didn't reach that. I mean, in going back to the rehearing order, paragraph 10, the final sentence, which I think your friend from the commission points to, It rejects petitioner's argument because they ask that the commission set aside recalculated auction rates by ignoring the Third Circuit's determination that PJM must use the originally posted LDA reliability requirement in the 2024-2025 auction, and they did that, right? They used that in the auction, rerun. It doesn't answer the question whether they must charge that rate ultimately to load.
Well, I think it's quite revealing that petitioner's argument here is that the February 23 auction results that did not use the LDA reliability requirement is their chosen remedy. That's where I think FERC was quite right in saying this is what petitioners have asked for in this case, is a return to the February 23 auction results. And that is what the Third Circuit explicitly rejected.
So if that auction had never been run and so that rate, the hypothetical and rejected lower rate never been generated by auction, then you wouldn't have this sort of marrying of the auction generated rate to a just and reasonable remedial rate. And if we're in that world and petitioners just said, look, this rate, unjust, unreasonable, FERC should use its remedial authority to model a rate that without this erroneous parameter, would you have the same objection there?
Well, I think there are a bunch of different ways to approach that question. So the first is, we are in a sui generis situation where what we have here is a Third Circuit decision that I think FERC did quite well in understanding on remand what it needed to do in order to accord with the clear mandate of the Third Circuit. And I think the mandate of the Third Circuit couldn't have been clearer. The PJM did not use the calculated and posted LDA reliability requirement as the tariff required. The tariff amendment is therefore retroactive. So I think there's an easy way to—
About the tariff amendment. So do you have a yes or no answer, just so that I'm not distracted looking for it? If we had had a situation like this, but there were no February 2022, was it 22 or 23, 23 rerun auction, if there was no effort to amend the tariff midstream, there was just the first auction, high rates, and FERC then looks at that under 206, whether that rate is unjust and reasonable, anything barring it from changing that rate?
Yes, Your Honor. So so I understand the hypothetical. There's no P3 decision. There's no Third Circuit review of the 205 adjustment. Is that right, Your Honor? You're just suggesting that there was
and there's no February 23 auction.
Right. So, Your Honor, if we assume that the auction was just run as it was from the get-go, and so we set aside the oddity of everything that happened around the Third Circuit and P3, which I think puts this case in a wholly different camp. But if we just settle on that, that is where the filed rate doctrine absolutely does apply. That's the second half of our brief. Now, I don't think the court has to resolve any of that to deny the petition, because I think just saying that FERC followed what the Third Circuit said it needed to do resolves this case. But again, to answer the court's question, the filed rate doctrine, as Oklahoma Gas and a legion of this court's cases make clear, is the filed rate doctrine does apply to a market-based tariff. And when it applies to a market-based tariff, then the question is the nature of what is being challenged, is it retroactive or is it prospective, right? That's the critical question. And the Third Circuit answered this question in this particular case. Now, I appreciate—
But your view is that it's effectively retroactive as to the rules of the auction. And their view is it is obviously not retroactive as to the price to be charged. And so someone would have to resolve the tension between those things. And the Third Circuit didn't.
Well, I disagree with that, Your Honor. So first, I think the Third Circuit did resolve that specific question. Now, one could disagree with the Third Circuit's resolution of that, but that's where I think there's an inter-circuit comedy issue, where because petitioners have chosen to come to this court rather than the Third Circuit, they're essentially asking this court to stand in judgment of the Third Circuit's determination that what actually is going on here is retroactive and not prospective. But second, the Third Circuit was was right, because what the Third Circuit said is the later downstream prices, those come out of the auction and the requirement under the tariff rules to post the LDA reliability requirements and then use that for each of the later steps.
What's the response to the suggestion that that argument means every price is immune from 206 challenge?
Well, Your Honor, I think the answer is if a tariff is run according to its tariff terms, the filed rate doctrine does apply in those circumstances.
So if you negotiate a price and file with FERC so that the filed rate says in the upcoming year, we will charge X amount, and it turns out X is unjust and unreasonable, you can't set that aside?
That is the very purpose of the filed rate doctrine, Your Honor, is that you don't do retroactive ex post look. In order to have a market-based tariff system work,
So
you have to have
FERC
confidence in those auctions.
On a prospective basis, FERC can never set aside an unjust rate?
Sorry, let me be clear, Your Honor. The question to that is the setting aside that you're suggesting, is it the setting aside, does it have simply prospective effect? And if the answer to that inquiry is yes, it is simply prospective, of course, you can set it aside under Section 206, consistent with the language in 206A. The filed rate doctrine.
When, in terms of prospectivity and retrospectivity on your theory, when does the rate get locked in? What's the fulcrum for purposes of prospectivity or retrospectivity? Is it when the parameters are set? Is it when the formula is announced and approved by FERC?
So first, Your Honor,
offer has been made. No, I take it it's not when the customers actually pay for the power.
So let me say at the outset, Your Honor, as we discussed at footnote 3, I'm standing up for multiple interveners, which includes PJM. PJM and the generator interveners may not see the answer to that question in identically the same way, but all of those interveners are here today because they think whatever the answer to that question is, that this is safely past the point where retroactivity attaches. So I just want to be precise in that. But Your Honor, I think it's clear that when what the Third Circuit said here is correct, which is you had legal consequences of the posting of the LDA reliability requirement because that incents behavior by the generators in order to secure capacity. That is the reliance that the whole market is designed around to have them then submit their bids into the capacity auction and then for actions to continue. That is where certainly there is attachment of filed rate, which is what the Third Circuit in P3 said. So again, even if one were to think that's wrong, that would be contradicting what the Third Circuit said in this very dispute among these same parties.
Just one last question. I think you just started getting at reliance. Can you explain in sort of practical terms how a bidder could have relied on the clearing price in making their bid? Or are you making a different argument about reliance?
No, they're relying, Your Honor, on the parameters because the parameters that get posted that then are obligated pursuant to the tariff to be used. One can understand what effects those are going to have potentially on what the market is going to shape up to look like. And then that incents bidder behavior.
So your clients knew that the auction was going to result in a 4X price? That would be a windfall to them?
No, I'm not suggesting they know that there was going to be one particular price or another, but the evidence in the record.
That's why I just don't know how they could rely on the outcome of an auction unless they were, colluding in advance.
There's no suggestion anywhere.
I'm not suggesting that either. That's why I'm confused about how you would need to know that how many people were going to put in and at what price, and that this weird outcome was going to result.
Let me just give one example that's in the record and our brief talks about, Your Honor, is the intermittent resources like solar and wind. If they're going to bid into the capacity markets, which they had some ability to be able to do, they might, because they can't necessarily guarantee that they're going to be able to run, and there are significant penalties if there is a capacity call and they don't run, they may have to engage in underlying hedges in order to be able to balance that out. In trying to have a prediction as to what this market is going to look like, it's going to have a real effect on whether or not certain wind and solar resources are going to bid into the capacity markets. And so they need to be able to have the certainty of the LDA reliability metric. So they say, look, okay, this is, I can bid into here, and then I can go and safely essentially obtain a hedge on my capacity requirement in the event that there's a capacity call. And for any reason, I'm not in a situation
to rely on the capacity that they're, for purposes of capacity, they couldn't predict the price that's going to result.
Well, that's right, Your Honor. There's not a
I
direct
understand.
prediction, but this is where, again, this goes to the whole reason why the filed rate doctrine is so essential with market-based tariffs. Now, can the rules of the tariffs be changed prospectively for future auctions? Absolutely, which is what the Third Circuit in P3 said, that this tariff amendment, the Third Circuit found it only couldn't be struck as to the already run auction, but not as to future auctions. And to the court's question, what happens if you had some, extraordinarily long, auction period or something like that? I'd suggest, Your Honor, that would just be a problem under Section 205, that sort of locking in some period could be determined to be unjust and unreasonable because it's true that you can't predict the future. But the question is, and this is where the distinction between prospective and retroactive, I think, does the work. In order for there to be market-based rates, there has to be market reliance on how that auction functions. And so you can't tinker with the rules of the auction after it's been run. If though what you're doing is making something that is purely prospective, that's not changing effectively the results of the rules of the auction, then you're in a different situation and the filed rate wouldn't apply.
Mr. Hughes, about the tariff, the attachment double D, the paragraph 11E, which talks about errors, and PJM can discover an error, and as long as it promptly notifies, that can be corrected. And your position on that is what?
It's what the Third Circuit said, Your Honor, which is that error provision simply doesn't do the work that's needed here, that would be reading far too much into this, and that PGM didn't think that would do the work. They didn't invoke the error provision. Instead, they did a tariff amendment. And again, this kind of gets back to, one maybe could disagree with what the Third Circuit held, but we think that's why the easiest way to resolve this case is exactly what FERC said, is FERC didn't have flexibility from the mandate of the Third Circuit. It did exactly what the Third Circuit said it should do, and that petitioners shouldn't here essentially be able to collaterally challenge the holdings of the Third Circuit, which includes, for example, how you interpret the error provision of the tariff.
So your view is that the rate paid for electricity to be sold in the future, in the year for which the capacity auction is providing, must be the auction price, period, end of story.
That is typically under the filed rate doctrine, yes, Your Honor.
If the tariff is clear about that.
If it is pursuant to the tariff terms, if the tariff is filed, that is, the filed rate doctrine protects market participants so they can rely on the tariff. And the court has been clear that the results of that can be harsh, but this is also a two-way street. So in Old Dominion.
We read that in the brief. So the rate is set when the auction clears? No, it's set in your view, it's set well before the auction clears. It's set when?
Again, this is where interveners may have different views.
Right, okay.
When an auction, though, has been run, everybody agrees that it has been set, and that resolves this case. But what I think
the role for 206, I know I've asked you this already. I'm just, the role for 206 under your view where the filed rate doctrine applies, it largely obviates 206 review.
Yes, Your Honor, except for if what the 206 complaint is doing is looking prospective. And the example here is one can file a Section 206 challenge to a PJM market-based rate tariff, just not for the tariff for the auction that's already been run.
Right. So you have no problem with the amendment insofar as it applies to years past the 2024, 2025. That's not in this case, and that amendment is going to be effective.
Yes, Your Honor. So for example, if PJM had not done this amendment prospectively, if the petitioner's claim was they bring a 206 complaint and say, applying this LDA reliability requirement for a future auction is unjust and unreasonable, Section 206 absolutely would have traction there, because what you're not doing is applying something retroactively to past conduct. That's the critical feature where the filed rate doctrine has to preserve a conduct when there is past conduct that is not subject to subsequent challenge.
All right, thank you. Mr. Ford, why don't you take 2 minutes?
Thank you. The key to this case is that auctions are rate setting procedures, that set rates for future sales under the seller's market-based rate authority. My friend from the commission read from paragraph 10 of the rehearing order, which I think bears on this question. That paragraph says that PJM's tariff specifies the rule for calculating the rate, the auction clearing price. And it goes on to say that PJM must use the originally posted reliability requirement to produce the rate. That's the rate for the future sale of capacity. And under the Federal Power Act, setting a rate does not immunize it from change. This case is solely about FERC's power under Section 206 to change an auction set market-based rate, not the wisdom of doing so. My friend from the interveners claims that once an auction is run, that's it. FERC has no power to change the auction clearing price. I would submit that that is very difficult to reconcile that position with the language of Section 206, with FERC's decision in Devon Power, which this court affirmed in New England Power Generators, where FERC looked at that case, looked at the question of how it would review auction set capacity prices, decided on the record in that case that it had discretion to apply a mobile Sierra presumption, which is a rebuttable presumption that auction set prices are just and reasonable. But that's the thing, even where a mobile Sierra presumption applies, the presumption is rebuttable, which means the complainants need a chance to rebut it.
So you had said, I think on your, when you were standing up earlier, that FERC would have had the authority to set its own prospective rate, even if it felt like it couldn't prove the exact rate as before because of the Third Circuit's decision. Could you say a little bit more about what that would look like? You know, what realistically FERC would have been able to do?
So I think that Citadel actually provides a template for that potentially. Citadel involved the suspension of a penalty constraint factor, which is essentially a market price cap in the energy market. FERC found in that case that allowing prices to rise to the cap because of a shortage of power due to transmission line maintenance, a short-lived problem that the entire market knew was going to be fixed, similar to this short-run problem of a mistaken parameter. It didn't make any sense to allow prices to rise to the cap in that context because doing so would do no good. It would elicit no new supply. It would elicit no transmission, no new transmission construction. So FERC's remedy in that case was, I believe, to set the price equal to, not to the cap, but to the highest actual offer submitted by a generator to supply power in that case. That would be one example. I'm not saying that that is the relief that we're requesting, but that's an example of what FERC could do.
That's fine. All right. Thank you.
Thank you, Your Honor.
Case number 24-5022. Tiffany Lewis, appellant, versus Douglas A. Collins in his official capacity as Secretary of the Department of Veterans Affairs of the United States. Ms. Huff for the appellant, Mr. Bardo for the appellate.
Good morning.
Good morning, Your Honors. May it please the Court, Sacred B. Huff on behalf of Appellant Tiffany Lewis. I will address two issues this morning. First, I will address the issue of timeliness. Second, I will address the glaring error of the District Court finding that Ms. Lewis's case lacks any evidence of discrimination, despite the fact that only 2 Black candidates had their scores lowered during the selection process. In addition, the selecting official claimed that the white selectee had the best interview, despite the fact that the evidence established that the selecting official never conducted interviews. Turning to the threshold issue of timeliness, Ms. Lewis's deadline to contact the counselor must be extended under the EEOC's regulations. The district court in this jurisdiction has recognized the general principle that a person should suspect discrimination upon learning that someone outside of their race or outside of their gender has been selected. However, the district court has also considered other relevant facts when appropriate. Here, even though Ms. Lewis knew that the selectee was outside of her race and gender, no reasonable person would have immediately suspected discrimination under the circumstances of Ms. Lewis's case. Any indicia of discrimination were obscured by other relevant facts. First, the selectee had a doctorate, which Ms. Lewis lacked. Second, Ms. Lewis was not interviewed for the position, so she was unaware that she was actually one of the top scoring candidates. Under those objective facts, any reasonable person would have believed that the selection was based on relative qualifications, not race, not sex. Ms. Lewis did not develop a reasonable suspicion of discrimination until she met with the selecting official's supervisor on an unrelated matter. During that conversation, the supervisor asked Ms. Lewis unsolicited about the selection process, even though she did not raise the issue. And then the supervisor asked Ms. Lewis whether the selecting official and the selectee were living in the 1950s or something. Any reasonable person would have understood the racial undertone of that comment. Therefore, upon hearing that comment, that's when Ms. Lewis contacted a counselor within 45 days of that meeting. Ms. Lewis did not wait until she had any proof of discrimination. She did not wait until she discovered the meaning of that comment. And she did not wait until she had any supportive facts of discrimination.
Well, she had circumstantial evidence. I mean, she had, in effect, the material for a prima facie case from the day the action was taken, which is, so there's a kind of irony here where the prima facie case standard is quite low. She was qualified. She had applied for the job. Someone who was not in her protected classes was hired for the job. So in a very minimal sense, she had that from the get-go. And then, I mean, I think the difficulty for you is the wording of the regulation, which seems to cut against the idea of a reasonable suspicion standard, where it permits tolling where the individual did not know and reasonably should not have known that the personnel action occurred. And so it's not asking whether the person lacked knowledge that discrimination occurred, but that the personnel action occurred. And I'm just not sure, despite the equities of Ms. Lewis's case and the irregularities that occurred in the granting of the promotion to someone else, it's not clear that you have the room that you would need under the regulation, the way it's written.
Thank you, Your Honor. I'd like to parse that out. There were several parts to that, but addressing first the question of the prima facie case. At the moment that Ms. Lewis learned of her non-selection, it is true that she knew that the selectee was white. However, at that time, she had no reason to suspect that he was not the most qualified candidate. Therefore, using your example of the prima facie case, Had Ms. Lewis went to a counselor at that time and alleged discrimination because she believed that the most qualified candidate, or who she believed at that time to be the most qualified candidate, Your Honor, I do not see that she would have established even a prima facie case when she's alleging what she believed to be the most qualified. Typically, when the employee raises a question of discrimination, it's because they believe that someone less qualified, or there are other circumstances that give rise to the inference of discrimination. Yet here, it was the fact that the only inference was that the more qualified white person was selected.
You're not asserting that to win, she would have to show that she was more qualified or that he was less qualified, but in order for that to raise an inference of discrimination, she would have to show that. I mean, someone who's qualified, even if at some marginal degree, the person who gets the job is more qualified, you can still make out a racial discrimination or a sex discrimination case if you're not as qualified, but you are qualified and you show that that the decision was taken based on an impermissible factor and that the employer was not seeking necessarily only the most qualified, but just someone who was qualified and brought other skills.
Your Honor, it's the fact that the discriminatory nature of the action was obscured by the fact of the objective facts of the selectee's qualifications. Also, going back to your second point regarding the text of the regulation, in appellant's brief, we state that the court need not defer to the EEOC and based on Loper-Bright, but upon further review of Loper-Bright, the Supreme Court was not addressing the commission's or a federal agency's interpretation of its own regulation. Here, the EEOC is not interpreting a statute. However, because it's only interpreting its own regulation, and it's the EEOC who says that even with their revised regulation, that incorporates the reasonable suspicion standard, it is our position that the court should give deference to the EEOC in reading its own regulation. So in multiple cases decided by the EEOC, they recognize the reasonable suspicion standard. So we disagree with the district court and appellee's position that the text of the regulation does not allow the reasonable suspicion standard.
I had a few questions about the merits. So the threshold one is, is your theory a motivating factor theory or a because of theory? If this case were to go to trial, what, as you likely know, that dramatically affects the kind of relief that you can secure at trial. And so have you made what's the theory? Which of the two roads are you going down?
A motivating factor, Your Honor.
Which means you can't get damages or anything like that. You just get declaratory relief, right? And in some sort of injunction and maybe some other things, but you can't get, you cannot get damages.
Under Title VII of the Civil Rights Act, yes, Your Honor,
yeah,
that you are entitled to compensatory damages.
In a Title VII case, if you only show that a prohibited factor was a motivating factor rather than a but-for cause, you are not entitled to damages.
Well,
Instead,
under
you have to show that it is a but-for cause in order to get damages. So it's why it's important to know what the theory is.
Your Honor, under the federal sector regulation, which is different from private sector. So even under a motivating factor, yes, a federal sector plaintiff would be entitled to compensatory damages.
Okay. And then if it does go to trial, it'll be your burden to show that race played at least a motivating factor. And I understand the argument based on reducing the scores. Is there anything else at trial in the record that you would point to affirmatively suggest that this selecting official was motivated by racial animus?
Yes, Your Honor. Of course, as you mentioned, there is the change of score, not only of Ms. Lewis's score, but another Black candidate score. But there are several because, again, going back to the district court's opinion, the district court found that this case lacks any evidence of discrimination, even though Ms. Lewis has demonstrated the falsity of several shifting explanations that the secretary has provided. And contrary to the district court's understanding, the falsity of the employer's explanation will allow a jury to infer discriminatory motive. Here, the explained reasons were shifted numerous times. But in addition to that, it's the fact that accepting the initial explanation that Ms. Lewis wasn't selected, the selecting official stated that she tied with another male candidate. Instead of interviewing both candidates, according to the selecting official, he lowered only Ms. Lewis's score. That aversion to interviewing any woman is also evidence of a sexist motive, but not only the shifting reasons, but his evasiveness. The selecting official had an opportunity to provide an explanation for his reasons on multiple occasions. There was a investigation from the whistleblower's office. There was a separate investigation from the EEO office. And instead of participating in those investigations, he resigned abruptly. So that evasiveness is also circumstantial evidence of discrimination. And I see that I'm over my time.
We'll give you a couple minutes and reply.
Okay, thank you.
Mr. Bardo? Can I ask you about the December meeting? And my recollection is that the three people involved, Reed, who got the job that Ms. Lewis wanted, Ms. Lewis and the supervisor above everybody, including Brinker, that meeting was because she was not given the opportunity by Reed to take some sort of 6-month assignment.
That's correct, Your Honor.
All right. And so how did the failure to get the promotion that Reed got enter into that conversation? Is it in the record?
The only thing we have in the record regarding that, Your Honor, is Ms. Lewis said that during the conversation, Mr. Burgess unprompted asked her if she had applied for the supervisory position. When Mr. Burgess was deposed, he said he didn't recall mentioning it. But we just have that testimony from Ms. Lewis. But the meeting was about, like you said, Your Honor, this opportunity to do a 6-month detail. And Dr. Reed said, I can't allow it because losing you will be detrimental. We value your work in the office, but you're welcome to escalate it if you would like. And Ms. Lewis elected to do so. But that's ancillary to the main controversy in this case. And we would just point that under this court's existing precedents, Tiffany Lewis's obligation to contact an EEO counselor within 45 days began on the date that she learned that she was not selected for the supervisory position, but that Ernest Reed, a white male, was selected instead. And because Ms. Lewis did not do this, she did not timely exhaust her administrative remedies. This court in the past has said that, has assumed without deciding that the reasonable suspicion standard applies, and nonetheless has held that that's a problem.
Is that a good legal rule if that were our rule? Anytime you apply for a job and someone who has a different race from you is hired, it's on you to immediately suspect racial animus?
It is, Your Honor, because the point of the regulation is to resolve these things quickly. The burden on
the effect is that if someone thought boy, I was qualified, but that guy, he's great. He's more qualified than I am. And so they don't suspect anything. And 6 months later, they find a piece of paper. It's an email that says, I didn't hire her because she was black. And that's a pretty good reason to suspect for the first time this was racially motivated. And the consequence of your rule is that claim is time barred because the person didn't run around with a sense of racial grievance in the first place.
Well, the text of the regulation, Your Honor, says, oh, that's the rule. It's within 45 days of learning of the personnel action.
Completely appreciate the argument on the text of the regulation. I'm asking about what constitutes reason to know that discrimination occurred. And it seems to me a very odd rule if we've really said you ought to immediately go and investigate just because someone who's not your race was selected for a position.
Well, the EEOC considered that argument when it promulgated the regulation, but it decided it was best to resolve these things quickly and encourage people to come forward to the EEOC. All a complainant would need to do is call the EEO counselor and say, I think there might be discrimination here. And the EEO counselor can then go talk to a few people and maybe come back and say, I'm sorry, ma'am, we acknowledge you submitted this complaint, but we looked into it a little bit and there's nothing here. They determined that was preferable to having these issues sit around in the ether.
I appreciate that. Yeah, so we have a couple of interesting cases, one of which Ms. Lewis cites in her brief that sort of say, notwithstanding the regulation, there is a more general equitable tolling rule. And so one of these cases is Al-Safi v. Vilsack, and it relies on a case that Ms. Lewis did cite, which is Lowe v. Heckler. And what Al-Safi says is we have this regulation, but separate and apart from it, we have a rule that the time within which EEO counseling must be sought is likewise told until the claimant knows or has reason to know the facts that would support a charge of discrimination. So that's not talking about the reasonable suspicion standard. It's importing the private employee equitable tolling rule into cases like this. Are you familiar with that case or know any reason why it wouldn't apply here?
Believe that's a Sixth Circuit case, is it not, Your Honor?
This is a DC Circuit case from 2016. I appreciate it wasn't cited in the briefs, but the Lowe v. Heckler case it relies on was cited, and it's a case exactly like this one. And it just says there's a free-floating tolling rule separate and apart from the regulations language.
Well, the tolling rule is in the text of the regulation, and it says that the tolling rule only applies when the person did not know that the personnel action occurred. So this would apply in a situation like one of the personnel actions in Miller versus Hersman, where the plaintiff knew the selection had occurred, but had not, but wasn't aware that the selectee was not in his protected class. And
That seems like a very strange, like just very narrow rule. If here Ms. Lewis conceitedly knew that the person was in protected class, but that factor is the stand-in for, is the person someone aggrieved by what they think is a discriminatory action, not just has been subject to a non-discriminatory action. Like if you look at the regulation and read it all together, it seems to me significant that the 1614.104A it's directed at aggrieved persons who believe they have been discriminated against. And then it talks about an aggrieved person having to initiate contact. But the aggrieved person is defined as someone who believes they have been discriminated against at the top of the regulation. And then in the discussion, there's a question about whether the person knew or reasonably should have known about the discriminatory matter or personnel action. And it seems, I know there's a dispute in the briefing about whether discriminatory applies only to matter or also applies to personnel action. It seems like that top line definition of an aggrieved person is someone who believes they've been discriminated against supports the distributive reading of discriminatory matter or discriminatory personnel action. And I guess the question is, why would the government take a different position? And maybe this is just repeating the question that Judge Garcia asked, which is, it seems like it fosters a kind of mistrust and seeing discrimination under every rock, as opposed to fostering confidence in the decision-making and only running the time when someone is alerted to something more particular that actually raises a suspicion or a concern, puts the person on notice that they should be investigating for potential discrimination.
Right. Yeah. Yes, Your Honor. I mean, that's a policy choice that the commission made and how.
And I guess I'm really focusing on the language of the regulation.
I mean, the
person aggrieved is someone who believes they've been discriminated against. And if they don't have reason to believe that yet, because even though they didn't get the promotion, they didn't know or reasonably know that the personnel action was a discriminatory personnel action.
well,
Why wouldn't that be the most reasonable way to read this?
because knowing that the selectee was someone of a different race or someone not in your protected class is enough to believe that you were discriminated against under these regulations and under this court's prior precedents in Stewart and in Drielac.
What about
and in
Miller, which really seems to adopt the reasonable suspicion standard? You would just say, yeah, but only insofar as you don't know the race or sex or protected characteristics of the selectee.
Well, Miller didn't really parse the text of the regulation. It didn't deal with the question of whether reasonable suspicion applied. But it's similar to Stewart and Drielac. It assumed without deciding that reasonable suspicion applied. And this court can do the same thing in this case by following Miller and Stewart and ruling that because Ms. Lewis didn't contact the EEO counselor within 45 days of learning of the personnel action, her claim is time barred.
But Miller does rely on the reasonable suspicion standard because Miller knew of his non-selection, but he only later learned of the sex of the selectee and therefore had a reason to suspect that sex discrimination might have been a factor. So I thought that was operative and not just assumed without deciding in that case. Am I wrong about that?
I believe Miller did use language to that effect, but that shouldn't alter the outcome in this case because unlike in Miller, Ms. Lewis knew of the sex and the race of the selectee.
Right. So it's the narrowness of the reasonable suspicion standard, not that the court didn't in fact embrace it, because it did embrace it there.
It did, but in later cases, the court has, like I believe Drielac was after Miller, where the court said that we haven't officially decided that the reasonable suspicion standard applies. But the court in this case, though, doesn't even need to answer that question where reasonable suspicion applies. It can simply follow prior precedent.
On the merit, do you agree with Ms. Huff that in a suit against a federal employer, the causation standard is motivating factor? Full stop.
I'm sorry, could you repeat that question, Your Honor?
My understanding was that at least in suits against private employers, the statute draws a distinction between cases brought on a motivating factor theory or a but-for theory, and the remedies differ. Ms. Huff said that distinction doesn't exist in cases against the federal government. Do you agree with that?
We disagree with that, Your Honor. Your Honor was correct that for a motivating factors theory, Ms. Lewis would not be entitled to pain and suffering damages, but were she to appeal, she could be entitled to back pay and attorney's fees and possibly injunctive relief.
So she'd be entitled to back pay, but not other forms of compensatory relief.
That's correct, Your Honor.
Was there so Brinker decided, the record says he decided he was going to interview 2 people. Was there some policy that required him to do that, or was that just his stated choice?
There was no policy, Your Honor. That was simply his stated choice for how he wanted to fill the position.
Okay. And doesn't that actually undercut the government's theory that this might have been improper, but if it was improper, it was just because he pre-selected his friend Reed. It actually makes it look like there was a legitimate interview process going on. And plaintiff would say, once they realized based on the resume scores that he might have to interview a Black person, they made some changes so that both Black applicants fell below the interview cutoff.
Well, Brinker simply made an error when he was combining the score sheets, and the story he told, it came out piecemeal, but it's part of one continuous story.
But this is something that I have a little bit of trouble about in the way the district court wrote the opinion. Saying that about the facts is to decide the issues of fact, not to ask whether a reasonable fact finder could find otherwise. A reasonable fact finder might decide that it's all one and he was making some kind of surmise about having, broken the tie. And then later he realized, no, I just made a keyboarding error. But without giving a spin or a preferential reading as a fact finder would, there are a lot of conflicts in the decision maker's testimony here. No?
Well, we would disagree, Your Honor. Mr. Brinker had always maintained that he only intended to interview 2 applicants, and he had thought previously that if 2 candidates were tied, he would break the score himself. But in this case, he didn't need to break the tie himself. In this case, he didn't need to break the tie himself because when he made that keyboarding error, changing one of William Itel's scores from a 5 to a 4, Ms. Lewis was 1 point below Nathaniel Turnipseed. And with regard to
Can you clarify?
Yeah.
So do you understand the relationship between Wilson and Brinker? Was it Wilson's title is executive assistant? He's sort of like sitting next to Brinker's office.
he wasn't. I don't believe he was in Brinker's chain of command. But he didn't know Ms. Lewis, and he didn't know any of the races of the applicants. So he completely went in blindly in terms of race as he was reviewing the names on the list. He testified that he didn't know Ms. Lewis's race. He didn't know Reginald Wright's race.
Although isn't there also at least conflicting evidence in the record insofar as I think both Ms. Lewis and Mr. Wilson said that they had been at meetings and various, gatherings of personnel where they had met him, they knew who he was, and they assumed that he would know who they were and that by observing them, he would know their sex and race.
Well, Mr. Wilson, I believe his testimony was that he may have seen Ms. Lewis, but it didn't seem as though he would be able to pick her out of a lineup.
Right, that's his testimony, but Wilson and Lewis raise a contrary factual assertion from which, as a matter of circumstantial evidence, a fact finder might find that was not the case, that he actually did know who they were and he knew their sex and race.
Well, that contradicts, though, Mr. Wilson's sworn testimony.
Exactly, but they've also given sworn testimony. That's why we have juries. I'm just saying that we were at a summary judgment posture here. And so his testimony would defeat her ability to win on summary judgment, but it wouldn't eliminate a material dispute of fact that would defeat the government's summary judgment.
Well, Your Honor, isn't Mr. Wilson in a better position than Ms. Lewis to know what Mr. Wilson
That would be an
believed?
argument for the jury, right?
It would be, but the plaintiff kind of misconstrues the deposition testimony from Mr. Wilson, and where he never says that he knew who Ms. Lewis was and knew what her race was. He just said, I may have seen Ms. Lewis at some conferences.
So
Let me ask you something. This record, even though it's on summary judgment, is replete with cronyism. And the way I read it, Brinker had made up his mind before anybody else applied with the telling Reed, no worries, I'll send you this ahead of time, so on and so forth. So that he'd made up his mind before Miss Lewis even applied for the job.
Well,
So how do we factor that in to whether there was any evidence of discrimination other than this third party making this remark?
well, it's clear from the record that Mr. Brinker and Dr. Reed had a professional friendship, so to speak. They would exchange resumes, they would exchange ideas on various projects they were working on, and it is possible that
Is there any dispute that he told him ahead of time, don't worry, you've got the job? I mean, there's all sorts of quotes.
I know there's testimony in the record to that effect, but that would just show evidence of pre-selection, and pre-selection in and of itself is not unlawful.
Isn't it in this situation? I think I read that all the people in the tier that Ms. Lewis and Mr. Reed and I think maybe that their tier was all people who were either women or members of racial minorities or groups or both. And so the applicant here out of, I think, was the white applicant who was male was Reed.
That's correct. But these are
So
all.
how can you disaggregate so-called cronyism from race and sex discrimination? I mean, if you look historically at, the development of civil rights law and the understanding through litigation of how discrimination often works, it's not because someone is being hateful. It's because they want to bring someone close to them, to work with them, who they identify with more, they feel more comfortable with. They might not feel comfortable working with someone who is not of their same race. And so that I'm not sure that the cronyism is somehow excludes a jury's ability on this record to find that there was in fact discrimination. Is that your argument, that it would exclude that, or just that I'd just be interested in your addressing that.
Well, in order to establish pretext, the plaintiff needs to show, one, that the employer's explanation was false, and two, that the motivation was discrimination, not some other reason. And given Mr. Brinker and Dr. Reed's professional relationship, you can't jump to the conclusion from there that it somehow was based on race. They knew each other from their days serving together in Iraq.
So if it's cronyism, isn't that separately? I mean, it's not part of Ms. Lewis's case, but isn't that separately a violation of civil service law? And did the agency ever pursue that? I mean, you have to have a posting. It has to be public. You have to follow certain procedures. It sounds like there's at least a violation of civil service law. No,
there is not, because they did post the opportunity, and they did review multiple resumes and interview 2 candidates.
So you're not saying that the government's legitimate non-discriminatory reason was cronyism?
No, we're not saying that, Your Honor.
The bias, if there was it, is cronyism.
Yeah, we're saying that to the extent Ms. Lewis has maintained that Dr. Reed had an unfair advantage. And to the extent that there is an unfair advantage, the record shows that it's because of their prior professional relationship.
This is going back to one of my earlier questions. If he had just decided to pre-select Reed, why did he interview 2 people? Why did he have all these scores go into the resume? It sounds like he hadn't pre-selected Reed. He wanted to, or at least someone could conclude, he wanted to interview the top 2 applicants, which is what he said. And then it sure looks like, well, right? Why did he interview 2 people if he pre-selected Reed?
He did.
Well, we're not saying that he did pre-select Reed. I mean, he knew Mr. Reed, he knew Mr. Turnipseed, who was the runner-up.
The district court said he pre-selected Reed, and he knew Turnipseed. So then he was faced with, if he wanted to, Is your position is that he did interview Mr. Turnipseed?
He did, yes.
Because he wanted to know if Mr. Turnipseed was a better applicant than Mr. Reed.
I would presume so, Your Honor. Yes.
Right. And what the plaintiff says is because he had committed to interviewing two people and he saw that the second person was going to be a Black woman and potentially a Black man, he instructed Wilson to lower the score for those two applicants. And Brinker and Wilson will testify that that didn't occur. And they will cross-examine and argue in closing that that is exactly what occurred, because otherwise this is just too fishy to buy. And why is that an unreasonable argument to make to a jury?
Well, there's no testimony that Mr. Brinker told Mr. Wilson to lower the scores of Black applicants. That's not in the record.
That would be direct evidence of discrimination, which nobody ever has.
Right.
Instead, you rely on circumstantial evidence, which is they mysteriously docked the score, not of the white applicant, Mr. Turnipseed, but of the two Black applicants. And when you look at the email exchange, it does not say, I looked at their resumes, and so I'm lowering the score. There's no explanation given for day one, good score for Miss Lewis, day two, bad score. Just says, here you go. And a reasonable juror could conclude there was a separate discussion about why he was doing that, couldn't they?
I would disagree, Your Honor, because there's testimony from Mr. Wilson for why he lowered the score. And the reason he lowered the score is because both Ms. Lewis and Mr. Wright had applied for a substantially similar position in Chicago. And Mr. Wilson was reviewing applications for both, and he took a second look at the headquarters list after he had finished reviewing the resumes for Chicago to make sure his ratings were consistent. And that's what led to the scores being lowered. He wanted to make sure the headquarters scores were consistent with the Chicago scores.
Okay. Thank you.
Thank you, Your Honor.
Ms. Huff, why don't you take 2 minutes?
Thank you, Your Honors. I want to address two very important factual points that were raised. Judge Henderson, to your point, you mentioned that there were 3 attendees to the December 26, 2018 meeting. However, there were only 2 attendees, the selecting official supervisor and Ms. Lewis.
But the district court was wrong then, because he said Reed was there.
Exactly. We pointed that out in our brief that is incorrect. On Joint Appendix page 139, you will see a calendar invitation from Burgess. That's the selecting official supervisor, and it's to Ms. Lewis only. So they were the only 2 people who attended that meeting, which made it even more bizarre that Burgess brought in, Burgess being the selecting official supervisor, brought up the selection process. Now, it was Reed who helped organize the meeting because he escalated the issue, but to be clear, he was not present.
Okay.
Going to another point raised by the secretary explained that one of the reasons that Wilson allegedly lowered the score of 2 Black candidates was because after he looked at the Chicago score sheet, which is an unrelated position or a different position, I should say, he then looked at the headquarters position. But if you turn to Joint Appendix 56 and you look at the email, Wilson had already completed the Chicago score sheet on July 20th, 2018. That's prior to when he completed the headquarters. And you see in the email, he's responding to his initial email providing the headquarters score sheets. So the whole explanation itself isn't worthy of any credence. And after he provided the headquarters position, that's again when he lowered the position. And that's where you see on July 24th, after he's already reviewed the Chicago score sheets, after he's already reviewed the headquarters score sheets, he then lowers the scores of the 2 Black candidates. And there's no dispute on that fact.
I'm not sure I'm following. I mean, I understand generally what the point you're trying to make, but it's not credible that he was trying to align his scores across the 2 promotion competitions by when he lowered Ms. Lewis's score because something about the chronology?
Exactly, because the secretary states that initially the Wilson provided the headquarters score sheets. Then he reviewed the Chicago score sheets. And upon reviewing the Chicago score sheets, he re-looked at the headquarters score sheets. But if you look at Joint Appendix 56, that's not actually what happened. So if that's his explanation.
But I had read that a little bit differently, that he had submitted the Chicago score sheets, as you say earlier.
Exactly.
And then he's doing the headquarters one, but then he reviews, meaning he looks back and he sees, oh, I gave a different score and I've already handed it in for Chicago. So instead of changing that one up, I should change this one down. That's what I took to be the narrative. Is that contradicted by the evidence of record that you're pointing to? The notion that he could have submitted it, but then referred back to it. That's not what he says.
Well, that's not what was explained, and that's not what's in the secretary's brief. In this secretary's brief, that they explained that he hadn't submitted the Chicago score sheets, but that's plainly incorrect because you see the email was already given on July 20th, 2018. Wilson then provided the headquarters score sheet initially on July 23rd, 2018. And then again, on July 24th, that's when he changed the score sheets. And specifically by changing, he lowered the scores of the two Black candidates.
So he submitted not only the Chicago one already, but he says he hadn't. And then he submitted the headquarters one. And after he submitted it, he changed it.
Exactly. At least that was the argument in the brief.
So I think really the hard point for you in this case is the timeliness point. And we have the reading of the regulations that there is a reasonable suspicion standard, but the really tough hurdle, I think, is that the Miller and Drylack seem to say that the reasonable suspicion standard is met as long as the claimant knows that the selectee was not in the protected class that she is in. And so it seems like a very narrow reasonable suspicion standard, at least as our court has read it. And I wonder if you have any cases that are strong on that or any authority that you would want us to look at. I mean, I know Judge Garcia raised a slightly separate authority that is from our court and binds us. But is there anything, more that you have on that?
Your Honor, this court hasn't addressed Ms. Lewis's circumstances directly. And even reading just the general principle of the reasonable suspicion standard, it doesn't contemplate other facts that may obscure the discriminatory nature. As we discussed earlier, generally when someone believes that they are the most qualified candidate and then they see that someone else has been selected, yes, under those circumstances, seeing someone outside of your protected class may give rise to a reasonable suspicion, but that cannot foreclose any other facts that may either obscure the discriminatory nature or situations like Ms. Lewis's, in which she's really the exception to the general rule. And even with the general principle, it's actually silent on, is there any other situation in which when you see that someone is outside of your protected class, is there ever a situation in which that alone does not give rise to reasonable suspicion? And just as a policy matter, it cannot be dispositive. And just the text of the regulation itself, the EEOC makes clear that it's intended to be a broad exception to this general rule to contact the counselor in 45 days. Because if you look at that last clause, that the deadlines can be extended for any reason deemed sufficient by the commission.
But the commission didn't extend in this situation, which is troubling. I take your point that there is a kind of generosity with exceptions, at least where the commission is concerned. But I guess my assumption would be that the writing the rule the way it is to leave broader discretion to the commission doesn't necessarily imply a broader reading of of a tolling that could be triggered by the claimant herself. And I guess the concern is if we were to adopt the rule that you advocate, that a plaintiff's reasonable belief that the selectee is more qualified than she was, and if that could indefinitely toll the limitations period until the claimant learns otherwise, it seems that many, many people would be able to make the same claim and render this 45-day time limit illusory. And I'm just not sure how, I mean, you say that her situation is unusual, but the rule that you've advocated, which seems, it just seems like it could blow a big hole in the 45-day limit.
Your Honor, if I may address that, it's the fact that the court, in examining what triggered reasonable suspicion, would have to look at what fact was available later that wasn't available when the plaintiff first learned of the non-selection. So that's why Ms. Lewis's case is unusual, in that she did have this triggering event, the meeting with the selecting official supervisor, and that may not be available, or that may not be the circumstance in other cases to blow up this 45-day deadline. Because typically, if someone believes that they have been discriminated against and they're not waiting for supported facts, because that's a standard that we're not advocating for, they can't wait until they have proof of discrimination, only reasonable suspicion. And that's what Ms. Lewis did. So in other cases in which other people, they may already have a suspicion, but then they wait to collect facts, they go speak with their coworkers, well, that would demonstrate that they had some suspicion, but they sought supported facts, or they sought evidence, and that's not what we're advocating for. But in addition to that, if it's an unusually long time, so let's say that a plaintiff waited 3 or even 5 years, well, other doctrines will apply. You have the doctrine of latches. So that would essentially kind of cure the issue that you have raised. But
What's the statute of limitations for her, putting aside the exhaustion?
Well, I guess, let me be sure in your question. You said the statute of limitations, to even bring the claim that it's the 45 days to contact the counselor.
But in terms of filing in court, assuming you've exhausted timely, isn't there also a period of time by which you have to, is it 3 years or?
No, Your Honor. So once there's been final action, so in this case, whether it's the final decision of the EEOC or even a final agency decision, she has 90 days to bring her claims to court.
I just have one detail, and that is, and I can find it in the record, but I just want to clear it up now. I thought no one was interviewed.
Well, Your Honor, that's a disputed fact. All the more reason that this case, assuming the secretary has articulated legitimate reason, needs to be remanded.
Does Lewis dispute, she obviously wasn't interviewed, that Turnip Seed was not interviewed?
Well, it's the fact that, again, it's disputed, but the selecting official conducted no interviews. The selecting official did not interview the selectee or any other candidate. Therefore, there's falsified records, because there are interview score sheets, but those are falsified records, Your Honor.
So I'll ask again, was anybody interviewed in your estimation, in your opinion?
No, Your Honor. No interviews were conducted.
Great. Thank you.
Thank you.
All right.
Case number 25-5177 et al. Novartis Pharmaceuticals Corporation at balance versus Robert F. Kennedy Jr. in his official capacity as Secretary, United States Department of Health and Human Services et al. Ms. Stetson for the Novartis at balance, Mr. Henworker for appellant Johnson & Johnson Healthcare Systems, Inc., Mr. Goldie for the appellees, Mr. Schultz for the intervener appellees.
Ms. Henderson, good morning.
Good morning.
I had heard that we had lost you to academia, but I'm glad to know that's not altogether true.
I appreciate that, Your Honor. Thank you. Good morning, Your Honors. May it please the court. My name is Kate Stetson. I represent the appellants BMS, Lilly, and Novartis. This is a case about the limits on an agency's statutory authority, not just whether the agency can exercise authority, but how it must do it. The agency here, HRSA, prohibited pharmaceutical makers from implementing 340B pricing with discounts or rebates, I should say, claiming that any rebate arrangement required pre-approval. But HRSA doesn't have roving statutory pre-approval authority. If HRSA wishes to prescribe a particular rebate process or discount process, the statute supplies one way for HRSA to do it, and that's through the pharmaceutical pricing agreements or PPAs with the manufacturers. There are no prescriptions in the PPAs for a particular rebate process or discount process. Therefore, manufacturers are entitled to implement customary business practices, just as they would with other purchasers, just as this court suggested in Novartis would be the case as long as the terms of an offer were reasonable. That should end this case. What the Secretary relies on is this provision in the statute that contains a parenthetical phrase as provided by the Secretary. So this is 340B A1. And I want to emphasize sort of the sandwich of words before and after that parenthetical. You have a header that says requirements for agreement. You have the first line, the Secretary shall enter into an agreement. The second line, under which the amount required to be paid, parens, taking into account any rebate or discount as provided by the Secretary, to the manufacturer does not exceed an amount equal to the average manufacturer price reduced by the rebate percentage. I'm shorthanding. So that entire provision has to do with the pharmaceutical pricing agreement. And that makes sense, of course, because as we know from other cases, Congress was almost notoriously stingy with the authority. Yes, sorry.
Finish your thought.
I'll finish the sentence. Stingy with the authority that it gave HRSA. Very limited rulemaking authority, limited authority under the PPA in the way that it could exercise its authority.
So the government has this argument that all this stuff about it has to be in the agreement doesn't get you where you need to go, because in fact, the result would be the agreement does not provide for a rebate mechanism, and so you can't do it. So it seems to me that this case is actually about a predicate question of what the statutory baseline is. It's either you get to do whatever you want until the Secretary says otherwise, or there's some default and you need the Secretary's permission.
Right. So just to qualify, the manufacturers wouldn't get to do whatever they want, of course. They would have to be, just as this court said in Novartis, in a different circumstance, standard customary business practices. Nobody disputes that the rebate processes that we're talking about here are standard business practices. Of course they are. But on your question, I think the government has actually answered that itself twice. The first time it did so with respect to the AIDS Drug Assistance Programs, ADAPS. So if you look in the joint appendix at pages 410 through 413. This is the beginning of volume 2. What you'll find are the references to the after the fact request for comment and ultimate Federal Register notice about the ADAP rebates. And one of the things that you'll see commenters asked was, what's the process for the rebates? How are these rebates going to be implemented? And over again, joint appendix 410, 411, 412, 413, what the agency says is, ADAPs and manufacturers are encouraged to follow standard business practices in designing the contracts and agreements for such a rebate mechanism. So that's point one. Point two is government counsel below at Joint Appendix 336 said in response to Judge Friedrich's question about how these rebate processes would be implemented, we wouldn't amend the PPA. They would implement them just as with ADAPs. So I think that answers the question. The PPAs are fine and operative and workable as they are. It's only if HRSA takes the unusual step of wanting to prescribe a particular rebate mechanism or discount mechanism in the agreement itself that it would run into the issue where it would have to amend the PPA. The default in your formulation, Judge Garcia, is a customary business practice, exactly as this court suggested in Novartis. And as I mentioned, no one in this.
So I think this parenthetical is confounding for sure in both directions, but maybe you can disabuse me of the following, which is, it seems like your position is that this means that the phrase taking into account any rebate or discount as provided by the secretary means unless prohibited by the secretary. And it seems it's at least much closer to taking into account any rebate if allowed by the secretary.
Right. Well, I think there are a couple things, Judge Garcia, if you'll indulge me to unpack that a little bit. The first is the 340B price is a lower price. So it's not a question about the secretary needing to put something in the PPA other than what's already there to effectuate the 340B price. That's what the rest of that provision under 1A is, how you get to that price. So with respect to the PPA not separately providing for a particular rebate or discount mechanism, I think that's a tell in a way. If you look at the PPA itself, so you can see this at Joint Appendix 435 and 438, the PPA actually doesn't include this parenthetical at all. It paraphrases A1. The manufacturer agrees to charge a price for covered outpatient drugs that will not exceed the average manufacturer price decreased by a rebate percentage.
So in other words, it says the price will not exceed the ceiling price.
Yes.
And one view would be that means as a default, you have to charge the ceiling price at the point of purchase. And if you want to deviate via a rebate or some kind of creative discount mechanism, you have to go to the secretary for approval. It might be, there's a specialized understanding in the pharmaceutical industry that price can be accomplished in different ways, but there's also a plain meaning version of it that says if the ceiling price is $100, the default is when you say, here's how much for this, you say it's 100, not 200, but I'll give you a rebate next week.
Oh, I think it's common parlance to say this is $100. You pay 200, I'll give you the 100 back. And more importantly, you know, the 340B price is a lower price. It's effectuated by one of two ways, right? An upfront discount or a back end rebate. So the idea that there is no rebate or discount suggested by the current PPAs is a bit of a fiction. Of course, there's a discount. That's how the 340B price works. I guess we can imagine a world where the 340B price is actually the same as the other prices that these manufacturers charge, but it has to be effectuated either by a rebate rate or by a discount. We know that both are permissible under the statute. The only question remaining is, does the agreement make provision for some particular rebate or a discount process that a manufacturer and a covered entity must follow?
But isn't the point who is the decision maker? Is it the manufacturers in the first instance? And I hear you, business practices, customary business practices, but there's no, that's the point in this case, is that there isn't an necessarily lawful customary business practice of manufacturer initiated rebates. Right? It's the providers who initiated it in the state AIDS clinic situation. And so that's really the question before us, is who is the decision maker? And as I read the statute, it contemplates that the secretary is the decision maker on that.
Well, Judge Pillard, first of all, I want to pay first attention to the comment you made about these rebate processes not being necessarily lawful customary business practices. I don't see any dispute anywhere on this record that these rebate models are anything but customary business practices. The question whether they're lawful, of course, is the HRSA's contention here that these manufacturers are prohibited from implementing rebates unless or until
The
the
question
manufacturer says yes.
is who decides before it
Yes.
gets implemented. So if you just took the position that it was a customary business practice to give a rebate a year later, knowing in advance that that's going to dissuade covered entities from participating,
I think
the
that
whole concern is that maybe the secretary ought to decide that and not the manufacturers.
2 points. And I do want to get back to this who decides question because the statute supplies the answer. But the response is the rebates here, we're talking about 7 days or 10 days. If we had a situation hypothetically where a manufacturer said, you'll get your rebate, just stick around for a couple of years and we'll send you the money. That is an egregious, non-standard business practice. And the manufacturer would presumably be subject to civil monetary penalties, which of course are one of the few things the agency can prescribe.
What provision of the statute would it violate? Is it the shall offer provision as what
Yes.
provision would that violate?
Yeah, I think it maps onto the panel's discussion in Novartis pretty well in that respect. There are certain types of standard contract behaviors that are wrapped into the PPA and into the transactions between the covered entities and the manufacturers, just as in any other standard contract. So yes, I
So
think it
what would
would.
the remedies be? It would be a breach of contract remedy by the providers if
Oh, no,
the
it would be an
rebates
enforcement.
were more than 7 to 10 days?
I think more to let's say somebody came in and said, I was told 7 to 10 days and I didn't get my rebate on the morning of the 11th day. I think HRSA would probably exercise its enforcement discretion not to pursue that manufacturer. If you had someone come in under Judge Garcia's formulation and said, I was told I'm not going to get my rebate until 2029, that is something that HRSA presumably could issue civil monetary
What would
penalties.
they be enforcing?
It would be enforcing the 340B statute's shall offer provision, among other things. I think that's probably the best hook for it. But I want to get back to this.
7 to 10 days? I mean, why not 6 weeks?
Let me pause because I was about to say that sounds like a standard business practice to me, but that's not in this record. What's in this record is that these manufacturers are offering their rebates within a week to 10 days, which is, if anything, a highly favorable business practice vis-a-vis the covered entities. I want to make sure I touch on this who decides question, though, because I think this is the crux of both of your questions, Judge Pillar, Judge Garcia. The issue of who decides is also resolved by the statute. The statute says, taking into account any rebate or discount as provided by the secretary. Then the question is, provided where? You have this entire statute provision that sets out the requirements for an agreement in the header, the agreement, such agreement, under the agreement. And so under the secretary's argument, what the secretary is suggesting is that that little parenthetical actually can exist somewhere outside the agreement, but provided where, when, or if the secretary decides to implement a particular rebate process, which it has not done, it may only do so in the PPA. Unless or until that happens, it's just a customary business practice.
As provided by the secretary is a pretty strange way of saying as provided by the agreement. If I say as provided by the secretary, it sounds like it's unilaterally decided, whereas agreement is a mutually agreed term.
I think in some ways, first of all, it's a contest of strangeness. I think it's far more passing strange for something to be completely divorced from agreement to suggest that the secretary can elsewhere provide somewhere for that particular rebate or discount model. But more to the point, if it said as provided in the agreement, that probably would be an express prerequisite that a rebate or discount model be specified in the agreement.
Okay, so
as
it's
provided by the secretary leaves discretion.
So if the secretary, because the secretary wants to do this rebate model pilot program, and what is it that diverges under the secretary's proposed rebate model pilot program from your proposed rebate models? Would you be satisfied with a rebate model that tracks what the government is currently piloting?
I think we would be satisfied. I have to hesitate because there are a number of different programs that have, my clients have different platforms, software platforms that carry out their rebate models. I think to the extent that the manufacturers are operating rebate model programs throughout the pilot program that look like the rebate models they would implement here, that's fine. The problem with the pilot program, of course, is it only applies to manufacturers whose drugs have been chosen for drug price negotiation and only to those drugs. That solves, only one part of the significant problem that we identified below. It solves the immediate impossibility problems created by the MFP and the inflation rebate issues. It does not solve the hemorrhaging problem with respect to duplicate discounts and diversion that we're talking about.
So if the secretary just wants to do the pilot program and doesn't want to make a determination about rebates until that pilot is concluded, on your view of the agreement as being the place where the secretary provides, then it would be permissible for HRSA to just next week, tomorrow, change the agreements so that rebates would not be permitted except under the pilot and unless and until the secretary has made a determination based on the data gained.
So two points. I think that change itself would be subject to notice and comment because that's the way that HRSA has proceeded before. In that event, we'd have a whole separate issue about
it does the agreements by notice and comment?
I'm sorry, does the agreement specify?
No. It writes the agreements by notice and comment.
It writes the one time it's amended the agreements in the past, which was after the Affordable Care Act, it did so through a notice and comment process. But the other thing I want to make clear.
That was to conform it to the statute, though.
Yes.
Yeah.
Yes.
But
the other
typically, if it wants to change something in the agreement, it does a notice and comment.
I think the one time that it has changed anything, it has been through notice and comment.
But is it your position that it would have to, I take it your position is that it would have to do that through notice and comment?
I think I described it to the district court as a down the road question. Our position is that's the way they've done it before. It conforms with the limited statutory authority that HRSA has. This is a spending clause provision after all. So giving the manufacturers an opportunity to understand and comment on what they're signing up for is particularly important. But let me make one.
Oh, sorry, just a practical question. These are annual contracts, is that right? They renew each year?
They're renewed year on year, yes.
So at a minimum, separate from notice and comment, if the secretary wanted to insert some new prohibition, it could do it for the upcoming PPA year. And then there would be questions about whether that's arbitrary and capricious and all that, but it would have that authority.
It would have that authority subject to the notice and comment issue that we've been talking about, subject to any arbitrary and
I guess
capricious
I'm just
challenges
trying to make sure I understand that if it is the case that the manufacturers lead, the question is for how long? And
Right.
so maybe a year. I know there's a 60-day notice provision, but okay.
Right. So, and I think that triggers the other point that I wanted to be sure I made in response to Judge Pillard's question, which is no one is saying, not even the government is saying, that a particular rebate or discount process must be implemented through the PPA. Remember at Joint Appendix 336, Government Counsel said below, if we conclude that these rebate models, subject to our pre-approval authority, are valid, of course there is no such authority, then we wouldn't amend the PPAs. We would just do it just as we did the ADAPs. So it's only if the secretary concludes that it wants to prescribe a particular rebate or discount model in the PPA itself that you get into this whole question about amending the PPA. Other than that, what both the secretary and we were talking about below is you just implement this as you did with the ADAPs, which is we trust that the parties to this agreement and the covered entities are going to engage in standard business practices. No one disputes, as I said earlier, that these rebate models are standard and customary business practices. So if this court concludes, as it should, that there's no roving pre-approval authority, or that the pre-approval authority is only underneath the PPA, then the answer is these letters should be vacated and the manufacturers should be permitted to implement their standard rebate practices.
I understood. Well, please.
Go ahead.
I understood there's maybe a third argument that even if there is a roving pre-approval authority, these letters were arbitrary and capricious. And it seemed like your strongest argument on that was that the letters did not address the non-assertion of a pre-approval authority in the ADAP or product replenishment situations. And usually a relevant question, if we got all the way to that question, would be, did your clients ever bring that past practice to the agency's attention and say, for example, you should not assert a pre-approval authority here because you did not in these two prior instances before the letters were issued?
The short answer is yes. And let me give you some cites. Lilly argued it at Joint Appendix 119 and 491 to 492 and Joint Appendix 623. I think those are all Johnson & Johnson arguments. BMS argued it at Joint Appendix 716 and 725. Novartis argued it at Joint Appendix 815. Same with product replenishment. Joint Appendix 119 Lilly, 725 BMS, 816 Novartis. So the argument certainly was made. You're also right, Judge Garcia, that the only reason we get to that kind of part of the drop-down menu is if you conclude that there was pre-approval authority, that it doesn't need to be located in the PPA, despite that sandwich of the rest of the statutory provision. And then I think the question is, HRSA plainly didn't explain itself when it came to not pre-approving ADAPs, and it certainly didn't explain itself when it came to sort of permitting this product replenishment post hoc rebate regime to grow up. So at the very least, in those circumstances, you'd have to go back and demand that the agency reconcile those positions. But you don't even need to get to that if you agree with us with what the statute says.
I've got a question about the first Novartis case. And when I read it, I thought, well, we've given them a whole lot of, the manufacturers, whole lot of running room. Why? Because the statute is silent. And Judge Katsas begins by saying statutory silence implies that private parties may act freely. But here we have agency silence because we don't, the statute says as provided by the secretary, rebate and discount. And then we have HRSA which has just never
Not provided
that.
in the
Never done
PPA.
anything with
Right,
that. So I guess my question is, how much can we rely on the first Novartis?
I think Novartis is not, I would say, controlling here, precisely for the reason that you point out. It's a close cousin, though, because I think the point Novartis reached, which is the Novartis panel reached, which is the statute, unless it says otherwise, permits manufacturers simply to engage in customary business practices. We are confident the courts can sensibly adjudicate questions down the road if they need to. That is the part that I think is particularly important here, because here, where you have the agency able to, but has not yet, implemented something in the PPA, the only place it can do it, prescribing a particular rebate mechanism, discount mechanism, then that Novartis fallback, I think, is where you land, which is customary business practices. We all understand that this is how it has worked. This is how it should work here. When you have a situation where eligibility is determined after the fact, the normal business process is for there to be a rebate. That's normally how it's done. And I think the statute here prescribes one way for HRSA to exercise some authority over a rebate or discount process. When it hasn't, and HRSA has remained silent, Judge Henderson, the manufacturers are able, within reasonable bounds, to implement their own.
So assume, and I know this isn't your position, but assume that the statute grants the secretary the power asserted here to limit the mode of price discounting and to exclude the mechanism of rebates until it's concluded further study. I take it your backup argument is that using that power for the first time required a reasoned explanation of a change in position? And
Sorry, go ahead. Sorry.
is that right? Just yes or no on that?
It's kind of an improv answer. Yes, and. Yes, and it required the reasoned explanation for a change in position, not because of some pre-Loper-Bright interpretive issue, but because the agency has exercised that authority in a differential way. So it's much more of a classic administrative procedure.
That is assuming that we think that the ADAP is an analogous situation.
You would have to think that the ADAP is an analogous situation and the product replenishment model is analogous. But I want to make sure we're talking about the same thing when we say analogous, because this is, I think, a point where the district court might have gone a little bit off the rails. The question is not whether ADAP rebates are similar to these rebates. The question is, when a rebate is a rebate is a rebate, and the secretary is saying we get to pre-approve rebates, why did it not pre-approve the ADAP rebates? So the similarity of the programs is another question kind of beside.
The secretary might be saying, we're going to pre-approve rebates when covered entities object to that. And we have never before been presented with the question whether to assert a pre-approval authority when the covered entities object. Here, we're going to do it.
And that would be a remarkable insertion into the statutory factors or the statutory authority that the agency doesn't have. The idea that it would favor covered entities' preferences over manufacturers is not something.
Ms. Stetson, the proposed rebate program that your clients want dramatically shifts who bears the financial burden in implementing 340B. And we know the whole purpose of the 340B program is to give these discounts to safety net providers. And so your clients' position requires those providers to give interest-free loans to manufacturers. And neither the ADAP nor the product replenishment model does that. So it just seems that it makes a lot of sense that Congress would have left that choice to the providers, but not left that choice, seen it as a different choice if manufacturers want to impose it unilaterally without the secretary's input. So and especially given the language of the statute that says as provided by the secretary. But my question was, I thought you were making an argument that the secretary is using this power for the first time and that it needs to have a reasoned explanation. And your first answer was, well, it needs to have a reasoned explanation because it's allowed other actors without express secretarial approval to do this. I mean, that assumes that there needs to be pre-approval as opposed to that the secretary can provide, see somebody doing something and say, no, we don't want that. We're going to provide that you can't do that, right? But so I guess the question is, if we assume that the product replenishment and ADAP are materially different, are you still arguing that there needs to be reasoned explanation for the agency's fresh use with respect to your clients of the secretary's power to provide the mechanism?
The short answer is yes, but I would like to give my longer answer. The first is to correct an important factual misunderstanding. The ADAP model, the rebate model, and product replenishment both require, in the first instance, a commercial purchase. There is no distinction in that regard between ADAP rebates, product replenishment, which of course is precipitated by a commercial price purchase, and the kind of rebate model we're talking about here. That's factual point one. Legal point two is, under the statute, manufacturers are permitted to offer the 340B price through rebates. That is the text of the statute itself. Now, you'll hear Mr. Schultz in a few minutes talk about how you should just erase that part of the statute, and it really should just be discounts. But the statute itself says rebates. Rebates mean pay the commercial price, get your money back on the back end. So then the third point I want to make is with
But
respect.
it's subject to the secretary providing otherwise, or no?
Subject to the secretary in the PPA, which itself would be subject to various, administrative procedure processes and challenges, providing otherwise, yes. But third, to your point, I want to make clear that what we're talking about is something that is highly unusual, by which I mean highly favorable to these covered entities. We are talking about rebates within 7 to 10 days, which the administrative record also shows might even put money back in the covered entities' hands before they even have to pay the wholesalers for the drugs that they got delivered. So the kind of scare tactics of the covered entities, which are not reflected, by the way, in the government's reasoning below about them having to carry a huge amount of float, are disproved by the prior practices, which also require a float, are permitted under the statute to the extent there's any float. And there's really no float at all in these circumstances.
I take it that what's at issue here for your clients is data that helps them determine duplicative claims or overuse. And I guess one way that Novartis, our Novartis decision bears on this is at least under that decision, your clients can already request as part of their offer to sell products, 340B products to providers at discounted rates, they can include in those offers requests for reasonable claims data. And if that's true, then why do you need this rebate program to generate the data?
I think as a factual matter, that data has, shall I say, not been quickly forthcoming. There's a lot of kicking and screaming and even litigation about producing data. But more to the point, what we're talking about here is not just producing data. It's imposing some order on a process that, as we described in our brief, is completely runaway and results in third-party administrators, the CVSs and the Walgreens of the world, going back weeks or sometimes months and finding what they think are 340B purchases that they can then post hoc get what we're calling a product rebate rather than money back. So that's what we would like to impose some reason and order on. That is what produces the real danger of duplicative discounts, and that is what also adds to the danger of diversion. But for our purposes, it's the duplicative discount issue and the need for data quickly in real time that would actually solve a huge amount of the problems that manufacturers have been operating under for about 15 years.
Just a question on how the secretary could provide. I understand the statutory argument that it's only in the agreement and that they lack rulemaking authority, but just separately as a practical matter, it would be completely normal to provide through informal adjudications, right? If they did have some sort of approval authority, you would come to them and ask for approval and they would do it.
I mean,
that's adjudications.
That's a
right?
big if, though, because our whole point is that the secretary doesn't have any kind of roving statutory authority. It's got extreme, that's why I used the word stingy earlier. Congress has been extremely stingy with the authority that it's given HRSA. It can do 3 types of rules and it can do the PPAs. So the idea that Congress would kind of create in this parentheticals, this separate authority that it could do some separate way that it really hasn't specified. That's the parenthetical wagging the dog, essentially. This has to come in the PPA if it is to come at all. And what you've already heard the agency say below is, we don't see the need to amend the PPA. We would just do this just as we did with the ADAPs. And that's an easy solution. We agree with that. Customary business practices, you just implement them, life goes on, no one has to amend the PPA at all.
Well, I think they would say what they did with the ADAPs was decide that the concept is allowed and leave the details to the industry.
What they did with the ADAPS was decide after the fact that the concept was allowed and leave the details to the industry. Our point is they don't get to decide up front the concept is allowed. We get to implement our customary practices. And the agency, if it wants to prescribe something different and particular, it can go back into the PPA and do it. But it need not go into the PPA. The default is, just as in any other contract, standard customary business practices.
So I just wondered if the state, the amici state and regional hospital associations argue that there's not any real conflict between the maximum fair price and the product replenishment model. You can do the maximum fair price prospectively. Does that solve your issue?
No. It doesn't. I mean, the maximum fair price, to the extent that manufacturers want to effectuate it through a rebate, they have to do that rebate in 14 days. And that's specifically provided for by CMS. So no, that the whole problem here, as we described in our briefs and our briefing below, is that the manufacturers have been put to this impossible task of trying to effectuate an MFP rebate within a certain period of time, with no idea about whether a new claim for a purported 340B rebate is going to come down the pike for that same purchase in 6 weeks or 3 months. That's the issue.
So you can move quickly in, I'm a little bit confused factually about, you're saying you would process rebates very quickly, but not if you've given upfront discounts?
Oh, no, I think the problem is who's moving at what and on what speed. Under our rebate programs, the manufacturers would give rebates directly to the covered entities within 7 to 10 days, full stop. When we're talking about the MFP rebates, manufacturers are required to rebate the difference back to the government purchasing authority within 14 days max. The problem crops up because of the belated weeks later, months later, or almost resuscitation of a claim that purports to be for a 340B patient. And that's the algorithm that we call the black box algorithm that the third-party administrators, CVS and Walgreens, all make their business and make a fair amount of money going back and finding prescriptions from past dispensations.
Aren't your clients wanting to just do their inverse version of the same thing?
No, our clients are just wanting.
They want to deduplicate. So everybody's looking for what they think they're entitled to. And it takes, so the question is sort of, should the secretary look at that and decide the best system? And you're saying, well, don't stop us from doing what we're doing while it does that. And I'm not sure I see that the secretary lacks power to do what he's doing, or the sense in allowing this new process. I know you say it's the customary process, but the rebates is relatively new for under 340B, right?
So were conditions on delivery to contract pharmacies. Those were relatively new under 340B and similarly grew up because of the abuses of the 340B program. So I don't think the newness has any bearing on whether these are actual customary business practices. If anything, the unusual, highly unusual practice here is for covered entities to seek an in-kind product rebate months after the fact for stuff they purchased months ago that they now say they're truing up to a 340B purchase. That's I think the issue. But I want to answer the point that you made about the secretary having authority to do this. Again, the secretary's authority is limited by the statute. It always is. The statute says it can do so only in the agreement. It doesn't have some kind of free-floating authority in that parenthetical to do something outside the agreement. That makes no logical sense whatsoever.
Do you dispute that in the agreement they could say no rebates allowed?
I don't dispute that they could say it in the agreement. What I would want to reserve judgment on is whether that would be subject to its own challenge. The statute
But it
talks
wouldn't be
about.
subject to a statute. My question is, would that be subject to statutory challenge or just
I
arbitrary?
mean,
capricious challenge?
if I were thinking kind of academically about whether it could be subject to a statutory challenge, I would argue if the secretary in the PPA said only discounts, no rebates, I would come in and say the statute says any rebate or discount. But that's a down the road problem if the secretary chooses to implement their authority in the PPA only by selecting discounts. And the other problem, of course, it would have is what we've talked about at length in our briefing below, which is this is the cleanest, quickest, most efficient way to get money back into the hands of the covered entities. So the fact that the secretary would, in your hypothetical, Judge Garcia, be prioritizing a discount system that is notoriously opaque and produces the kind of duplication and diversion risks and actual occurrences that we've been talking about would suggest that it would have a significant arbitrary and capricious problem on its hands as well.
Okay.
If there are no further questions. Thank you, Your Honor.
So I'm sorry, Ms. Stetson, it is your view that the regulations approving the ADAP rebate models that were already in effect were necessary? In other words, that those models were operating unlawfully until then?
No, I think the models were operating perfectly lawfully. Who knows what was going on in 1998 and why the agency felt like it wanted to put a finer point on the issue. Maybe the comments and questions shed some light on that, because a lot of the comments and questions, as I said, were directed to this issue of, well, how do these rebates work? What are the mechanisms?
So it was an information gathering. It fulfilled an information gathering function for the agency, but in your view, what weren't necessary? The regulatory.
I don't think they were necessary. They are instructive, though, because where the agency ultimately landed was to say, and that's Joint Appendix 410 to 414, look, all these questions about the particulars of the rebate program, we are going to leave it to the manufacturer and the covered entity to work out the details. And that's all we're asking for here.
Thank you.
Thank you.
All right, Mr. Handwerker.
May it please the court, Jeff Handwerker for Appellant Johnson & Johnson. I want to start by responding to some of the questions that you asked my friend, Ms. Stetson. The PPA here is a unique type of contract. The Supreme Court in the Santa Clara case said that the PPA is a statutory opt-in. So it's a contract that enables manufacturers to opt into the statutory scheme. Because of that, Judge Henderson, my answer to your question about the difference between agency silence and statutory silence is there is no difference in this case. The agency's silence in the PPA is the equivalent of statutory silence because the PPA is essentially part of the statutory scheme per the Supreme Court's holding in the Santa Clara case. A number of points flow from that. This court's decision in Novartis becomes significant. In that case, as the court knows, you evaluated whether statutory silence on delivery conditions allowed manufacturers to proceed freely using customary business practices and answered the question in the yes. The same is true here. If you look at the PPA, as my friend noted, Section 2A, which is JA 436, specifically hews very closely to the language of A1 in the statute. And as Judge Garcia noted in his questions, it specifically says manufacturers must charge a price no higher than the ceiling price. HRSA could have gone on and said something about the parenthetical. It could have said manufacturers.
It's a little confusing because everything you're saying just confirms that this whole case just turns on what it means to charge the ceiling price. And nobody talked about that in their brief. You assume that there is no statutory default and it's just customary business practices. The government assumes that there is some other statutory default that you need permission to diverge from. And I get maybe the other Novartis case is helpful to us, but it does not discuss this statutory language and whether there's a baseline default pricing mechanism. It is not informative on that question.
The ceiling price is a statutory formula that derives from the Medicaid rebate statute. The formula is the average manufacturer price minus the Medicaid unit rebate amount.
So one conceivable reading of this statute would be when the ceiling price is $100, you must go to the covered entity and say, you can buy my drug for $100. You cannot go to them and say, buy my drug for $200 and I'll give you $100 next week. And we need to know which reading is the right one. So why is the right reading that you get to charge $200?
In the pharmaceutical pricing context, the transaction price is the list price net of discounts or rebates. That is a standard business practice in the pharmaceutical industry. It's recognized in a number of contexts. For example, in the Pharma versus David case, the court specifically said in evaluating what prices needed to be disclosed under a California transparency law, that it was price net of discounts and rebates. In the Robinson-Patman context, when you're evaluating whether a price discrimination has occurred in the pharmaceutical space, you look at the price net of discounts or rebates. Under the Medicaid rebate statute.
So this is, I appreciate all of that and common usage. If I were, and I'm not saying this is correct, but if I were to just stare at these words, the amount required to be paid, you're either going to, the argument would be you're going to require them to pay 100 or 200. And then there's a parenthetical that says taking into account any rebate or discount. And it's a little bit odd to say amount required to be paid on its own envisions using a rebate and then having a parenthetical that says maybe you can use a rebate.
Yeah.
It suggests that the preceding term doesn't envision the use of a rebate, doesn't it?
Well, I think it does. I think it suggests that the amount required to be paid could take into account a rebate or a discount.
If allowed by the secretary.
Well,
If
it
provided by
says
the
as provided by the secretary, right? Not as approved or allowed, but as provided. Yes, you're correct. There's a second sentence in A1 that I think is important. And it's, as you all noted when my friend was speaking, it's the shall offer provision. The shall offer provision was interpreted by this court to mean make a bona fide offer. And the court parsed the words price and offer and reached the conclusion that offers could include various terms. The court also went on to say that manufacturers are free to impose reasonable conditions on their offers so long as those conditions do not result in a covered entity paying a price higher than the amount required to be paid, higher than the 340B ceiling price. In the context of a rebate, here, the rebates are being paid within 7 to 10 days. J&J's proposed rebate model in this case had a 7-day commitment. It also has a technological feature that would allow payment of the rebate upon purchase rather than upon dispense. So it's not the situation like what the interveners are suggesting, that there could be 6 months or longer between the time they purchase a drug and the time they're paid the rebate. That compares with the current discount model. And I just want to explain this a little bit for the court. Under the current discount model, drugs are purchased through wholesalers and then sold through to pharmacies. The pharmacy then would dispense to a patient of a 340B entity. And then at some point after the fact, that sale would be recognized as a 340B eligible sale. And there would be an invoicing process back to effectuate the 340B price. That takes a much more significant period of time than the rebate models that are proposed in this case. So as my friend noted, the actual impact of the rebate models here on covered entities will be significantly less than under the standard wholesaler payment terms, as we note in our brief. With respect to the other questions that were asked, the must offer provision plays an extremely important role in this case. The must offer provision provides a limiting principle on the impact of rebates on covered entities. If there is a situation where a rebate model results in a covered entity paying more than the 340B price, the covered entity has remedies under the statute. They could pursue an alternative dispute resolution. HRSA could impose civil monetary penalties. There are significant consequences to manufacturers if they do that. So this is not a case.
Isn't this their whole view of this case is you say, no big deal, rebate, it'll be easy. And they're saying, no, this is a huge change and we don't have the money to do it. And we don't trust that you're going to give it to us in 7 days. So that's exactly why the secretary has to kind of come in and settle the dispute.
So there are a few points to unpack from that, Judge Garcia. First, the claims data that are required to be produced here, the record is replete with information about this, are standard claims data that covered entities collect and provide in transactions in other contexts. They have provided similar claims data with respect to contract pharmacy sales per the Novartis case. So this is not an undue burden on covered entities. Second, the rebates.
If they're providing it as a standard matter, I have the same question that I had of Ms. Stetson about, if we've already held in Novartis that you can request reasonable claims data as part of your offer to sell, then why do you need this rebate program to get the data?
So the challenge is under the current system, Your Honor, the claims data are not available in a timely fashion. Rebate models will enable data to be provided in real time, which is extremely important, especially when you think about the Inflation Reduction Act deduplication requirements that my friend mentioned. So the rebate models provide for a faster turnaround of that data, which allows for the deduplication that is needed.
And if you over deduplicate, the remedy for the providers is what?
So the deduplication will occur not in the 340B program. So the 340B providers are going to receive the 340B price through the rebate. If there is a deduplication, it would be to other purchasers, not to the 340B entities. So there's two sides to the deduplication, Your Honor. There's the 340B discount, and then there's a discount to someone else, like the MFP or another party. And any deduplication here would occur not in 340B, but rather with the other party. So the covered entities are going to be made whole with the rebate within the 10-day window, 7 to 10-day window.
All right, thank you.
Thank you.
Mr. Baldwin.
May it please the court, Maxwell Baldy for the government. The 340B program exists to enable safety net healthcare providers to stretch their scarce resources in order to serve some of the nation's most vulnerable and underserved populations. The Secretary is conscious that suddenly upending the system covered entities have relied on for 3 decades risks imposing additional costs and burdens on providers and consequently reducing patients' access to care. As I think the court has recognized this morning, this is a dispute over whether the Secretary may take steps before this happens, whether he may take steps to study and address these concerns before manufacturers may switch from upfront discounts to rebates. Plaintiff's position is that they may unilaterally implement rebates for whichever providers and drugs they choose on largely whatever terms they choose, and the Secretary has not reserved the power to review, disapprove, or condition the rollout of any rebates. So consistent with that view, each plaintiff gave the secretary a short fuse ultimatum. Eli Lilly, for example, after the system operated the way it has for 30 years, demanded a response to its proposal within 19 days and proposed to implement its model 39 days later. And then when it didn't get immediately what it wanted immediately, it sued. But Section 340B permits rebates and discounts only as provided by the secretary, and the secretary has not made provision for the rebates plaintiffs propose. Therefore, the statute prohibits plaintiffs from rolling out rebate models until the secretary signs off. I have six, sorry, Judge Garcia, do you want to?
Maybe there'll be six.
I was going to say, yeah, I have sort of 6 reasons why our statutory interpretation is correct, and I think that's where the meat of this dispute lies. I'd start with the text, which says that the secretary must provide, he must make provision. So yes, there are rebates and discounts, but the secretary has to provide for them. He has provided for every other form of rebate or discount or payment method that has occurred before this point, but he has not provided for the ones plaintiffs have proposed.
Please. Is your position that there is a statutory default pricing mechanism? So if the secretary never provided for anything, what are the manufacturers supposed to do?
No, our position is that what the statute requires is for the secretary to make some provision before to enable 340B pricing to occur. And if you were to, I'm sorry, Judge Phil, I didn't want to.
So
You can finish your sentence. I just have a question about this, but
yeah, so if you were to look at, for example, Congress passes this in 1992, it sets an effective date in 1992, the pricing agreement comes out later and the first guidance comes out both in early 1993. And nothing has happened to this date. And the agency has to say, okay, here's how it's going to work. You need to true up for everything between the effective date and when you sign your agreement. And then going forward, the agency described this sort of upfront discount scheme. But at every point, the agency said, this is how you're going to do it.
so it seems like HRSA has previously exercised its power ex post. You have it doesn't seem to me it's necessarily essential to your position that the secretary must pre-clear any program in order to provide for it. For example, with these state aid apps, they were doing it and then it was approved ex post. And that would suggest that the statute does not require ex ante the providing for the program. By the same token, it could provide, and I take it has provided, that it's not going to allow the rebates of the petitioners here. It's going to do a pilot program, study it, and then decide whether to provide for it. And there's so how much is really riding on this notion that the secretary has to pre-clear any program in order to provide for it?
Our central argument is that the secretary has to make provision. That could be, as he's done with upfront discounts, saying this is the default system, go and run with it. I would dispute the premise that the secretary has done retroactive approvals. If you were to look at the ADAP guidance, it makes clear, this is the 1997 guidance, quote, most ADAPs have drug purchasing systems that prevented their participation in the Section 340B discount program. So they were not participating in 340B. They were negotiating sort of program to manufacturer discounts that would replicate what they could get if they could get into 340B. But the guidance makes clear, we've pointed to sort of contemporaneous agency documents that say they're outside the program and they're being undercompensated by millions of dollars because they don't have all of the agreements with all the providers. And the secretary said, this system, this sort of informal system that you've come up with seems to be working. I'm going to take it from being outside 340B and bring it inside the 340B fold and then recognize it and allow it to go forward for all ADAPs. But that is not a retroactive approval because it was happening sort of outside a program that the ADAPs could not access.
What's the answer to the similar question about the product replenishment model?
Yeah, so I would point you to what the secretary said in 1994, which is that there's no requirement for separate inventories. And in 1996, again, there's no requirement for separate parentheses physical inventory because a separate data system will be used to verify appropriate dispensing. The product replenishment model is essentially the combination of two things. It is a combination of fungible inventory and upfront discounts. It is not in any meaningful way, I don't believe, a rebate program.
So you would say that was approved in the 1993 guidance. If we approve if we read the 1993 guidance to say I provide for discount program.
Yeah, 94, 96 saying that we don't have to, the inventory is fine. 93 saying the basic model is discounts. Again, I think the secretary has discretion in how much control he wants to exercise. So he could say something like with ADAPs, like the system you seem to have works, I'm bringing you inside the fold, do what you think makes sense, or he could provide more detail as he did, for example, with the pilot program. Judge Trilla, you'd asked about the pilot program. I just want to make clear, the pilot program, I think, as of now, BMS, Janssen, and Novartis are all participating with their negotiation program covered drugs. And so that solves some of their concerns, but the secretary has not sort of said how the pilot program affects whether and when and what he's going to do with the proposals that are still before them. So that has not changed our position on sort of the finality of any decision that the secretary just hasn't made on what to do with these rebate proposals.
So one of the, as you go down the chart of arguments, one of the arguments is that the secretary didn't adequately explain why it was intervening here when it hadn't in the past.
Yes.
And I take it, at least as to, for ADAP, the answer is it wasn't 340B, and for product replenishment, it's not even a rebate program. But that's not in the letters, right?
So the discussion of why the product replenishment structure is different is discussed in the letters. The Johnson & Johnson letter at 455 has a couple of sentences saying, ongoing purchases after this initial sort of purchase is at the 340B price, distinguishing it. As for the ADAP, the administrative record contains the 1997 letter, which explains sort of everything I told you. It's not in the letter itself, but this is an informal, whatever this is, it's an informal adjudication. So we're in Overton Parkland and you just need a discernible path from the record to what the secretary said. But I'd also say the agency's position is one of consistency, that this is what we have always required. And Fox versus FCC says that if you change your position, you have to have there's a heightened standard for explaining it. But the converse of that is if you're just acting consistently, you don't need to explain every time why you're being consistent. The agency's view is that this is how this works.
I had not read the 1993 guidance to say, I will provide that the only way of pricing is going to be through an upfront discount and nothing else is required. Is there a citation for somehow where we could look to discern that?
So I would say if you were to look at 58 Federal Register at 27291, the secretary says, quote, a manufacturer must sign an agreement with the department agreeing to charge a covered entity a price for covered outpatient, agreeing not to charge a covered entity a price exceeding a bunch of words that mean the ceiling price, retroactive to the date of the bill. So I think that's describing, as the secretary said, I think in 1996, in 1997, that describes only this sort of.
But put aside what they definitely said the backhanded thing in 96 or 97.
Right.
But the language you read runs right into the argument that they are making, which is that charge the ceiling price itself assumes that you might do so through a rebate or a discount, and that is common practice in the pharmaceutical industry. What's your response directly to that argument?
I think our response is that if you were to look at sort of what the agency has done consistently, for example, in the 90s, taking the position that ADAPs could not access 340B pricing through rebates and recognizing that as a real problem and producing reports trying to figure out how to deal with that problem. That is just inconsistent with the idea that rebates are permitted and that they can just do it.
Let me ask it this way.
Yeah.
If the following sentence, the amount required to be paid shall not exceed the ceiling price, if that language which is essentially what you read to me, prohibits a rebate model, then the statute prohibits a rebate model. And you told me that the statute does not set a default pricing mechanism.
Right, because the statute does not prohibit a rebate model. It expressly contemplates a rebate model.
Right. But it does say amount required to be paid shall not exceed the ceiling price.
Right.
Parentheses.
Yes. Taking into account.
Confusing words. But the point is, in the
Crystal clear words, Your Honor.
in the guidance, the language you quoted just says, it doesn't reference rebate or discount. It just says, you shall not charge a price above the ceiling, above the ceiling price.
Right. And I think that silence is, an indication that you have to do the normal method, which is like the rebate, you have to do something different. And maybe, Your Honor, you could take that to say that there is that means that discounts are
the normal,
the default. When you asked me that question before, I took you to be asking, did the secretary have to make provision for discounts? And our answer to that is yes. Whether you would want to read that as sort of the ordinary way and rebates require more, I don't think a lot turns on that.
I wonder if you could respond to Mr. Handwerker's argument that there's no feasible way of ensuring deduplication between the 340B discounted price and the IRA discount, given the timeline of the IRA discount and the current structure of the 340B program. What would it mean for manufacturers to give the MFP prospectively?
I'm not sure, Your Honor. My answer to that question is that the pilot program solves it. When the opening briefs were filed, there was a problem. By the time that we filed our brief and the replies were filed, I think that problem disappeared.
But the pilot program is only for certain part of that market, right?
Well, but it's for drugs covered by the negotiation program, which is where this deduplication program exists.
Okay.
So there were 10 drugs in the initial year, and that's what's covered here.
Okay.
I want to talk for a second about sort of these pricing agreements and how they function and what they are. My friend Ms. Stetson pointed to the fact that we said that we wouldn't amend the pricing agreement to implement rebates. And that's exactly right, because as the Supreme Court explained in ASTRA, they are a regulatory opt-in device. They aren't setting substantive terms or limits on sort of how this works. And they're not certainly the exclusive regulatory device. And so, yes, the agency's position is that, unless the court were to read this provision very differently to say that like everything has to appear in the agreement, which is never how it's been understood, no amendment to the agreement would be required. It is simply this means of opting into the scheme. But I think the idea of shoving everything in the manufacturing agreement doesn't work either for a couple of reasons. First of all, the agency has, I think it's tinkered with like a little bit of language here and there over the years, but it has made only one substantive change. And that was after the Affordable Care Act said, the second sentence of A1, these things must expressly be in the agreement. And the agency, asked for viewpoints on what the language should say. And then it asked manufacturers to sign an addendum because that's what the statute then required. There have been other changes that Congress has made to the statute that have not gone into the agreement because those are not, there was no language saying, and you must put these in the agreement. The agency's view is that manufacturers are still bound by those, but I don't know what their view would be if everything has to be in the agreement. And it's also—
Can you remind us when you say there are other changes that HRSA has made to the agreement without, there are other changes that they've made without putting them in the agreement. What are you thinking of?
So there are, all in section 340/256B, subsection D1B, Romanets 2 and 4 has an obligation for manufacturers to provide rebates in certain circumstances. That's a statutory obligation, not in the agreement. D1B Romanet 5, requiring manufacturer audits in certain circumstances. D1B Romanet 6, a different type of civil monetary penalties. D3A, a different dispute resolution than what the agreement contemplates. This is all the stuff that Congress has done over the years that the agency has not gone and changed this agreement because it's never viewed it as a device to where it's anything more than an opt-in.
Are they making a distinction between something that entails secretarial discretion and something that is just required? I'm not sure. So for example, as provided by the secretary is making a choice and they're saying, well, that has to be through the agreement. Are the provisions that you're citing provisions in which there's similarly some kind of discretion on the part of the secretary? Or does that not matter?
I'd want to look at the text more closely before I definitively said there's no discretion involved. I certainly don't want to foreclose the secretary's decision.
They're not really making that argument.
Yeah, but that's not, I don't think that makes much of a difference. I mean, to the extent that their argument that it requires discretion, so they need notice, we think the notice comes from the statute because that's where the obligation comes from. I'll also point out that, everyone came to the agency first with varying levels of asking for permission versus saying we're going to do it. But no one thought like, if we just were totally allowed to do this, if we just sort of start doing it, let's see what happens. I think it was understood that this was something that the agency was going to have to weigh in on to some extent.
Some of our questions, we're getting at this sort of big picture statutory question of who leads and who decides. And on one view, you would assume the secretary decides first. But another reasonable view would be that industry comes up with innovations and new ways of trying things, and they are constrained by the duty to give bona fide offers. And if they stray too far, they'll face various penalties, and suppose you could even find cause and terminate the agreement. Why is that? I mean, maybe your argument just doesn't hinge on this, but do you think it would be absurd and bad to have the manufacturers lead, and why?
Yeah, I think it'd be inconsistent with the scheme Congress designed. If we were to look at Astra, right, this is a case about whether covered entities are third-party beneficiaries of the contract. And the court's reasoning turned out two things. One, it's not that kind of contract. And two, the secretary is in charge of this process. To the extent that the court finds it helpful, the legislative history, the House Report at 12 says that price reductions will be implemented at the discretion of the secretary as either point of purchase discount, a rebate, or other mechanism. If you look at the text, which says as provided by the secretary, that's there. But I'd also look to sort of the potential practical consequences here. The view that the plaintiffs have put forward in their letters to the secretary, in their briefing here, I think at the podium here, is that it's not a relevant legal consideration what impact this has on covered entities. So if you look at the Johnson & Johnson letter, they say the secretary's first question is, have you studied the impact of this proposal on the scope and breadth of healthcare access? And Johnson & Johnson starts their letter saying, we don't think any of this is legally relevant. We don't think you can consider this. But here are your answers. So I think there's a real problem where you have essentially two industries with competing interests and an agency in the middle to say that despite Congress's design, we're going to turn it over and just let one half of the equation regulate itself. The agency has not said rebates are good or bad. We haven't said these proposals should go forward or shouldn't. But what the agency has said in their letters, in these lists of questions they put forward, is we have concerns and we want to study them before you can move forward. And the record contains at least enough evidence to say these are concerns that should be addressed. There's the letter from 340B Health saying that they're smaller entities operating on razor-thin margins couldn't handle these costs. There's a letter in the record at JA 891 from 189 bipartisan members of Congress warning that the model would reduce resources available for providing services to patients' communities. Yeah, the 340B program contains some major hospital systems. It also contains small community health centers that don't necessarily have the ability to turn on a dime. The secretary's view is that he has to consider these things and figure them out. And whatever decision he makes, one group or the other is probably going to sue and I'll have to justify it. But the framework is that he can mediate these things and prevent a sudden change so that, after 30 years of the way something's operated, 58 days later, it all changes with whatever consequences.
So this is a record specific question, but when I asked you earlier whether there is a response in the letters to this claim that there was a departure from the ADAP and product replenishment approach. You cited the J&J letter, and that's true.
Yeah.
But the other letters do not respond to the product replenishment example. For example, does that mean we have to vacate and remand those letters for more explanation?
I don't think so for two reasons. One, if I recall correctly, the second J&J letter at the very least was posted like online. The agency's position was known. The position that the government
We
took,
should just read that as applying to the other.
the position the government took in district court and that both sides have used to their advantage or disadvantage is that there's one administrative record that's considering all these things together and it sort of read things across the letters. If that's the position, if you want to remand with instructions for the agency to put that paragraph in the letters, you could do that, but I don't think that's going to help very much. I want to make two more points quickly. The first is plaintiffs have put a lot of weight on the shall offer language. I'll note that was added in 2010. So by their reading, Congress created a scheme that from 1992 to 2010, they actually could have just done whatever they wanted without these good faith obligations. And that doesn't seem to make sense of the scheme together. The second point, I want to get back to something I was saying about the manufacturer's agreement, which is just say what amending the manufacturer's agreements over the objections of the pricing agreements over the objections of the manufacturers, what that would mean is just sort of uncharted territory. My friend Ms. Stetson called these down the road problems, but if this court issued a decision saying that manufacturers can do what they want and we'll figure it out later, the agency has never tried to amend these agreements over the objections of the manufacturers. I'm really not sure exactly how that would work. I'm not taking the position they can't do it, but I'm saying there's a lot, there would be open questions there about how this whole process works and what's required and what factors they have to consider, what process they have to use. And so we're looking at, a difficult process and lots of litigation and potentially manufacturers just sort of taking over the secretary's regulatory role for years while we sort this out. I understand the plaintiff's position to be that if in 1992, when he was only contemplating, or 1993, when he was only contemplating discounts, if the secretary had put in the agreement the words, use discounts or rebates, but only rebates if you ask me first, this would all be fine. And I think saying that this whole system turns on like a potential oversight that was made 30 years ago at a time when no one was contemplating this problem because it's not in the agreement, even though, the structure and the text of the statute doesn't make clear that it has to be in the agreement. I think if your statutory interpretation is getting you to that point, you should look at it with a new set of eyes.
All right, thank you.
Thank you.
Schultz.
May it please the court, Bill Schultz for the interveners. There are three aspects of the drug companies' programs which make them unlawful. First, under these programs, the drug companies will decide whether the 340B drug is being purchased for a lawful use. And this is something that really was not mentioned, but it's critical, but not mentioned by the plaintiffs. Second, the discount is paid for by a rebate rather than upfront. And third, the drug companies would require the providers to provide data to be used to make this determination. And there doesn't seem to be any limit as to how much data could be required. I'd like to address each of these. First, under the rebate plans, the drug companies decide whether the provider's claim for a rebate is valid, whether it is for a 340B patient, and they decide that before providing the rebate. They would do this by reviewing the data provided by the 340B covered entity. And only if it's satisfied that their test is met would they pay the rebate. In essence, and this is I think the most critical point I want to make, the drug companies will be taking over enforcement of the law and enforcing the law before the discounts are provided, or in their case, rebates, rather than after the fact. And this, we think, is flatly inconsistent with the way the 1992 statute is structured and the way it has always been interpreted and applied. Today, under Section 340B, the providers purchase the drugs from the drug companies at 340B prices. The provider keeps records, and any questions about the legitimacy of that purchase are answered after the fact by audits conducted by HRSA or by the manufacturers.
I have a threshold question about these issues, which those arguments might be persuasive, but why are they ripe for decision now? HRSA's position is they have not made a final decision on whether to approve or not this rebate program. And your arguments would suggest that they shouldn't approve them, can't approve them. But isn't it premature to resolve those questions?
Well, the difference
on a different ground.
The difference we have with HRSA is we don't think there is authority to approve these rebate programs.
Absolutely. And my point would be, you could certainly file a lawsuit challenging the pilot program on that basis, but I'm curious whether this is the wrong time and wrong vehicle to make that argument, because HRSA hasn't, or maybe they have, they haven't really taken a definitive position on these models.
Well, I think the posture of the case is HRSA has said to the companies, you can't go ahead with these programs without our approval. And the companies have come back and said, no, we don't need your approval. And what we're saying is there is an authority to do these programs anyway. And I want to get to the rebate point, that we don't think they can do rebates, but this is a different point, and it's one that really wasn't discussed previously. But it's the key point, because the whole point of these programs is it's not whether it's paid through a discount or rebate. It's whether the companies get to decide whether the 340 claim is legitimate. Is this a legitimate 340B patient? Is this something we should pay? And if they decide no, then they don't pay the discount or rebate. And that's a huge shift. And what we're saying is it's inconsistent with the statute, because the statute set up a fairly elaborate system of audits that happen after the fact. And those audits would be unnecessary. Essentially, the companies are getting the information up front, and they're really flipping the script and deciding. I also want to point out, I think this is contrary to the Supreme Court's decision in Astor versus Santa Clara County. In there, you had providers, not the companies, but providers were suing the companies about the discounts. And they were saying, you're not complying with the statute. And they had a third-party beneficiary theory based on these provider agreements that we've been talking about. And the Supreme Court said, even though you're a beneficiary of the contracts, that Congress set up a system where HHS was supposed to do the enforcement, or HRSA was supposed to do the enforcement. And it said to the providers, you now want to enforce the statute, but under the statute, HRSA does it. Well, we think the manufacturers are doing it on the other side here. And essentially they're saying, we're going to enforce the statute. We're going to decide whether these are 340B patients, and basically take that away from HRSA. The second reason, in our view, that the plan violate the statute is we think that rebates are unlawful, and they have been since 2010. In 2010, as part of the Affordable Care Act, Congress expanded and strengthened 340B. It included provisions to ensure the accuracy of ceiling prices calculated by the manufacturers, included the Civil Money Penalty Authority, but it also amended the first paragraph of the first subsection of the statute, that's A1, by adding a second sentence. And that sentence says that manufacturers participating in the 340B program, quote, that the agreements for the manufacturers, quote, shall require that the manufacturer offer each covered entity covered outpatient drugs for purchase at or below the applicable ceiling price. In other words, the offer has to include the discount. It has to be at or below the applicable ceiling price. And that language, we think, doesn't leave room for rebate. It really codified the way the whole system had been structured and run up to that point. The one exception is the ADAPS, and I want to talk about that in a minute, but this is the way it had always been done, and Congress codified it in language that we think plainly does not leave room for rebate and doesn't leave room for debate.
And would it outlaw the inventory control model, I'm forgetting the exact.
Oh, the replenishment
The
model?
replenishment model, right.
No, and let me explain why. In the replenishment model, the essentially the hospital, if it's a hospital pharmacy or the pharmacy, sells the drug to the patient, and then the provider, the hospital or the provider, goes and every time purchases the drug at the 340B price. There's no rebate involved there.
The only thing is the notion that they are buying them not at or below the applicable ceiling price in the first instance to get the thing rolling. And I guess that's not true if it's a contract pharmacy, but if it's the provider and they're have in inventory the covered drugs that they purchase at retail price,
And
then they are in effect buying them at or below, above the.
I mean, that's the argument that the drug companies make, but they don't, once they sell the drug to the patient and it's a 340B drug, then after they sell it, they go buy it at the 340B price. They don't, under this model, they're not buying it before they sell it, but once they sell it, they go back and buy it at the 340B price. And they do that every time. And so there's no rebate really that's involved in that. It seems to me very different from a rebate. And, the only other way to do it would be to buy it in advance, but it doesn't seem to me to matter whether you buy it in advance or after the fact. The point is, when they buy the drugs, they're buying them at the 340B price. Maybe I should say a word about the ADAPS too, because the key difference there is that it's voluntary. In other words, the statute says that the manufacturers have to make the drugs available at the 340B price. And then if a provider comes, in this case, it's the ADAPS, and they came because, I can explain why, but it's totally impractical to do upfront discounts because they only had one pharmacy and the ADAPS are for the whole state. And so they voluntarily work on an agreement with the drug companies where the drugs are purchased and then after the fact they can get the rebates. That's very, very different from what's being imposed here. And obviously the costs are very different as well. Now, on the point that the statute prohibits rebates, HRSA acknowledged this in their letter to Sanofi in this whole back and forth here, and it's cited in Judge Friedrich's opinion at JA 399. The courts below, both courts below said that this second sentence, if you read it to say no rebates, it would be inconsistent with the parenthetical language that we've been talking about in the first sentence, taking into account any rebate or discount as provided by the secretary. But the problem with that is that paren modifies amount required to be paid. In other words, the first sentence says the secretary enters into an agreement under which the amount required to be paid, taking into account any rebate or discount as provided by the secretary. So this is not how the money is paid, rebate or discount. It is what the amount is. And this paren gave the secretary authority, presumably for good reasons, to adjust that amount. And as we pointed out, there are two times back in history when the secretary has exercised that authority and adjusted the amount. Once for new drugs for which there was no average sales price, and once for drugs where inflation was so great that the actual discount amount exceeded the price. And so that resulted in the penny pricing policy. Finally, I want to say a word about the data requirements. That's the third sort of piece of all of this. As has been pointed out in the Novartis case, the DC Circuit said data requirements could be imposed, but it said it understood that in that situation, the burden was minimal and part of ordinary business practices. There, the requirements were imposed on the pharmacies. Here, as I understand what the companies are proposing, would be data requirements, not just from the pharmacies, but from the hospitals and other providers. And I think the record shows they can be very burdensome. They can require hiring different people and compiling different data and so on. And I think as Judge Contreras pointed out, it's unclear if rebates aren't permitted, what they would use the data for anyway. The data is very much connected to the rebates, which, as I've argued, are not permissible.
Okay.
If there are no further questions, I thank the court.
Why don't you take 5 minutes?
Thank you, Your Honors. I'd like to make 3 quick points. The first is, in the last 5 seconds of Mr. Baldy's argument, you heard him say something that he had not said before, which is that the statute permits the secretary to make this provision outside the PPA. That was the statement that I've been waiting for the entire argument. He made it right before he sat down. Maybe the reason is that there really is no statutory support for that principle. As we discussed when I was last up here, the statute talks about the requirements for an agreement, the secretary entering into an agreement, the price under the agreement. So the only way that this court could conclude that that parenthetical, taking into account any rebate or discount as provided by the secretary, actually empowers the secretary to do something completely outside the agreement is by saying that the secretary has some power that is otherwise constrained to within the agreement in that provision, just not that parenthetical part. And I didn't even hear Mr. Baldy making that argument today. Point number 2. Mr. Baldy spent a lot of time talking about how the secretary was acting consistently when it came to, for example, the product replenishment program. The first thing is, I want to make very clear, Mr. Baldy talked about how back in the 1990s, the agency approved a certain type of commingling inventory. We are not complaining about shelving processes. What we are complaining about is this new system that the covered entities and their contract pharmacies and the third-party administrators have developed in going back weeks or months and purchasing at 340B prices to make up for product long since dispensed. That is what we are complaining about, not shelving. And if that is something that is even counts as a rebate or a discount, questionable, then if the agency presumes to be acting consistently, I would expect to see the same kind of public notice threatening covered entities with termination from the program unless they get pre-approval for their product replenishment systems. Third and finally, this question about amendment of the PPAs. I think I hear all of us in vehement agreement that the agency does not need to amend the PPAs. The manufacturers can simply do what they do as reasonable contracting entities, which is impose standard business practices, including rebates, including discounts as the parties, as the manufacturers choose. But here's the kicker. What you heard at the beginning of Mr. Baldi's argument was the manufacturers are suggesting that the secretary can't review or disapprove what the manufacturers are doing. Of course it can. If the secretary concludes that the manufacturers are not acting reasonably, if they are implementing crazy rebate programs, if they're implementing something that is simply outside the pale, the secretary has all sorts of nuclear artillery available to it to punish that manufacturer for doing what it's doing. But on this record, what the manufacturers are doing is extremely well within standard business practices, quite beneficial to the covered entities, in fact. And on this record and under this court's decision in Novartis and under the plain text reading of the statute, the manufacturers should be allowed to implement those rebate programs.
Can I ask one question?
Yes.
If we set aside the first argument, which I know you don't want me to, but I now take the government to be saying that our early guidance, the combination of them, it's not just that they talked about shelving, it's that they affirmatively provided for a discount model.
Right.
And that's why you've been allowed to do a discount model for the last 30 years. And we have not provided for a rebate model. It's as simple as that.
Right. So couple answers. The first is a lot of this is post hoc rationale. And this is not just, as Mr. Baldi said, kind of shedding more light on the path they followed. This is just new stuff going into the record on appeal. But more importantly, when you talk about approving a discount model, if that in fact is what it does, I think you pointed out, it's not like they said, we approve the discount model. You have to read between and underneath the lines to get that. But even so, the product replenishment model is nothing approaching an upfront discount model. So if the secretary has approved a discount model, then the covered entities have a real current problem with the way that they've been doing business. If there are no further questions.
Thank you.
Thank you, Your Honor.
Let's see, Mr. Why don't you take 2 minutes?
Minutes? Oh, my goodness. I'll be quick, Your Honors. I just want to respond briefly to some of the points made by my friend, Mr. Schultz, for the interveners. First, J&J's rebate model at issue in this case simply validates whether a purchase has been made and a dispense has been made by the 340B entity. It does not look into whether it's an eligible patient or not, and I just wanted to clarify that. The J&J model at issue in this case does not change the universe of eligible claims under the 340B program. Second, the intervener's argument here would read out the word rebate from A1 in the statute completely. Their only response to that is to point to the penny pricing guidance from HRSA, as well as the new drug guidance. Neither of those documents, neither of those guidances or regulations refers back to A1 as the source of authority for its promulgation. The penny pricing was under their civil monetary penalty authorization from Congress, and the new drug did not assert any authority at all in the statute. So there's nothing that they have pointed to that suggests that the word rebate in A1 means anything other than its plain meaning of rebate. I would also note that their argument, if accepted, would invalidate the ADAP rebate program. They have no response to that other than to suggest that ADAPs are voluntarily and manufacturers are voluntarily participating in a rebate model, but that's beside the point. If a rebate was not permitted in the statute, they wouldn't be allowed to do it. Finally, just a quick word about the pilot program. J&J is participating in the pilot. We appreciate that HRSA has done this. I note that the pilot is time limited. It is testing a new technology, and our expectation would be that if the pilot is successful and HRSA decides to roll it out, that they would do so through a PPA amendment. Unless the court has any questions, I will conclude.
All right,
Thank you.
It's